The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right. Mr. Matthew, you may proceed. Good morning.
Good morning, Your Honors. May it please the court, Nathan Matthews for petitioners. The Forest Service and BLM have again permitted Mountain Valley Pipeline to construct a gigantic pipeline across steep, erodible slopes and streams in Jefferson National Forest. There are many flaws in the agency's approvals, but the central issues are still sediment and erosion. I'd like to begin with the agency's failure to address the consequences of their own predictions. In 2018, when the agencies had predicted that sediment in some streams would increase by 10% over baseline, this court held that the agencies arbitrarily failed to address the impact of the predicted increase. The agencies repeated this error here. The new hydrologic analysis, despite its flaws, predicts even more sediment, increases of 10, 20, or more than 30% in many streams, twice the sediment predicted in the prior analysis. Agencies had a specific substantive obligations to address the consequences of these increases, but it again failed to do so. First, BLM had a Mineral Leasing Act obligation to, quote, ensure that activities in connection with the right-of-way or permit will not violate applicable water quality standards, and to ensure that MVP had the, quote, technical and financial capability to avoid such violations. Nowhere in the record does BLM address these statutory provisions. BLM's silence regarding these obligations is itself fatal to BLM's approval here. Just as in 2018, BLM's silence regarding co-location in the Mineral Leasing Act undermined BLM's prior approval. And as I'll explain in a minute, BLM did not even implicitly consider this issue. But first, I'd like to address respondents' post hoc arguments about Virginia's Clean Water Act Section 401 certificate. The 401 certificate did not relieve BLM of its independent statutory obligation and is not legally controlling. Respondents point to Clean Water Act Section 511, but Section 511 is specific to NEPA. When Congress enacted Section 511, Congress knew that agencies addressed water quality under other statutes as well. But not only did Congress choose not to curtail those other authorities in Section 511, Congress explicitly preserved them in Clean Water Act Section 401B, enacting a broad savings clause which provides that nothing in Section 401, quote, shall be construed to limit the authority of any department or agency pursuant to any other provision of law to require compliance with applicable water quality requirements. So contrary to the agency's brief, no authority even suggests that the 401 certificate is conclusive with regard to the agency's substantive obligations, and Congress has in fact explicitly said otherwise. And here, BLM needs the 401 certificate to be conclusive or to somehow strip BLM of authority because BLM didn't address it in the record. This is not a case where BLM said it was deferring to another agency's judgment because BLM just said nothing at all. In any event, the 401 certificate isn't even persuasive here, and deferring to it would have been unreasonable because it considered very different facts. Virginia issued its 401 certificate on the basis of FERC's 2017 EIS and other contemporaneous data. So Virginia could not and did not consider the evidence before BLM now. That includes the amount of sediment. BLM predicts twice what the 2017 EIS predicted. It includes the duration of impacts. In 2017, Virginia expected, based on the old EIS, that impacts.
Are you essentially asking us to rescind the Virginia water quality certification issued in 2017?
I am not. I'm just asking BLM to meet its own independent and parallel statutory obligation, which is specific to federal land. But I am not asking this court to pass any judgment about the continuing validity of Virginia's 401 certificate.
Okay, thank you.
Well, let me answer. How does that requirement interact with the fact that this right-of-way grant requires Mountain Valley to acquire new water quality permissions before crossing each river?
Mountain Valley Pipeline is currently seeking new Clean Water Act authorizations for water body crossings outside the National Forest, But I don't believe that the current proceedings apply to the 4 crossings within the national forest. The Forest Service has already approved in this, and BLM have approved in this proceeding, switching to boring under the water crossings in the national forest. We separately argue that that approval was inappropriate, but because boring under streams has already been approved in the national forest, I don't believe that there's any ongoing proceeding other than what we have in this case about the water body crossings in the national forest.
So your answer is that it doesn't require that?
I don't expect Virginia DEQ to have any, a further formal opportunity to weigh in here. I don't think that there is a new permit proceeding for the water body crossings, and so I don't believe that there's a trigger for any ongoing new certificate from Virginia.
So you part of your argument here deals with this need, essentially saying there's a pre-decisional review that was required because in effect this undersecretary wasn't the one to make the proposal, that the proposal actually came from the Mountain Valley Pipeline. How do you, it seems to me, the undersecretary did it unless you're saying there's something nefarious or that they usurped something. I know there's allegations to, at least statements to the effect that really wasn't involved in it, and that in actually what happens, it almost sounds like ultra-virus type things in the corporate law. But tell me again your basis for saying that?
Certainly, Your Honor. So 36 CFR section 218.13, the regulation that the Forest Service relies on here, provides a narrow exception to the pre-decisional review process for projects that are proposed by, that originate with the Secretary of Agriculture or the Undersecretary. And the Forest Service could have promulgated a regulation that said you don't need pre-decisional review for projects that are just approved by the Undersecretary, but that's not what they did. The text of the regulation says proposed, and we're asking the court to enforce the plain text of that regulation because it cabins how often this regulation is going to be applied.
So when would this pre-decisional review been done? And I understand, if I understand it correctly, you're talking about basically an interagency sort of review, or at least comments or something of that sort. When would that have been done?
Rather than just publishing a final record of decision after they had issued the final supplemental environmental impact statement, the Forest Service would have published a draft record of decision, which would have gone out for objections. That's what the Forest Service did in 2017, is they put out a draft record of decision concurrent with the final environmental impact statement. We would have, likely many people would have submitted objections, is what they're called, to that, and the Forest Service would have had to resolve those objections.
So when would that have happened?
In January of 2021. I expect that the Forest Service would have issued the draft record of decision on the same day that they issued the final record of decision, or instead of the final record of decision. So that, but wouldn't that just give cause for a delay? I mean, you did it in 2017, and if you want to expedite it or move it along, what would keep them from asking the Undersecretary to do it? I'm assuming they asked, or was it the Undersecretary who asked to do it? I explain that process. The record indicates that it was Mountain Valley Pipeline who suggested designating this all as an action proposed by the Undersecretary in order to skip the pre-decisional review process. We see that at JA 1663. But I don't, if you're asking what the purpose of the pre-decisional review process is, it would have been that we could have presented our objections to the agency and possibly resolved them without having to come to this court again. It would have provided another chance for us to point out the errors to the agency, and hopefully some of these mistakes could have been fixed without having to come to court.
So it seems like your main argument here, at least in terms of the other questions you bring, particularly in terms of the sedimentation analysis and impact errors, is that when you're looking at disclosure of individual mitigation effectiveness, that they don't account for that 15%. Explain, is that right?
So we have two broad buckets of arguments about sediment. The first is that even if you credit the hydrologic analysis and think that everything they say is credible, they still don't explain the consequences of that sediment. If sediment increases by the amount that they say they expect it to, We don't know what the consequences of that are going to be. And part of that is we don't know whether the resulting sediment will violate Virginia's water quality standards. We also don't know whether the resulting sediment will comport with the Forest Service's obligation to maintain and restore water quality and aquatic habitat. So we do have a bunch of claims that, even if the court were to credit the hydrologic analysis, et cetera, we still think that the agencies didn't take the hard look at sediment and didn't meet their substantive obligations. But we also think that the hydrologic analysis was not justified. And part of that is that we don't believe that it's explained by the evidence they actually cite. We also think that the hydrologic analysis needs to be reconciled with the real world data that shows that, for example, the United States Geological Survey monitoring data that we presented, that shows that in the real world, it looks like actual sediment from MVP's construction was 10 times what the current prediction of it would have been. And we think that the agency's complete failure to even acknowledge that information rendered their decision arbitrary and capricious.
So help me out here. There's a use of a model here, and you seem to have a problem with using that model to come up with numbers like the 15% and other things. What's the problem with this model? As I understand the model, and you got to help me out here now. This is your area, not mine. But this model takes in considerations of, I guess, things like baseline and maybe other factors that come into play, which are the natural factors that are outside of that. And so what is the problem with the model? And isn't it done by an expert in terms of how they come up with these numbers?
So we don't have a problem with modeling per se, but the agencies have an obligation to address whether or not this model's predictions are accurate. And we don't know whether that's a problem with the model, a problem with the way that they use the model here, or something else. But if the model makes predictions that simply do not match what we see in the real world, the agency needs to explain that. And maybe the answer is to either use a different model or to tweak the way they're applying this model, or to do something other than modeling. But in the first instance, our concern is that the agency didn't even acknowledge contrary evidence in the record that seems to say this model here, the way they've done it so far, isn't working.
So now, is it your contention they just relied too much on the model or exclusively on it and should have used additional things? Because it seems like you're saying the model's okay, but you need something else.
I personally have some doubts as to whether the model, okay, but that's not the standard, is whether I have doubt.
No, it's not.
The legal claim is that they needed to consider all available information, and the Forest Service in particular has a regulatory obligation, 36 CFR 219.3, to explain that what it's using is the best available scientific information. And here, we contend that the data from federal monitors that were installed in order to look at the impacts of this pipeline sure seems like real world evidence of actual impact, and that evidence of actual impact is plausibly the best available information, better than just a prediction based on a model. We aren't saying you necessarily need to base all of your analysis on the USGS data, but the agencies at least needed to consider it and explain why the model was reasonable despite this conflict between the model predictions and the real world data.
So you got just a little time, and I'll tell you, when you look at this, there's no way in the world you could sit and argue every argument that you made in those briefs at the time, but you couldn't do it. It would take half the day. I believe that to even get there. So why don't you give us a bullet list of those points, if you're dealing with alternative crossing, the failure to comply with the 2012 rule or whatever that you consider. You just got about a few seconds, but I don't know how we even cover it. It's hard to argue a case like this.
I agree, Your Honor, and I appreciate the sympathy on that. I just, on the water quality standards point, I'll emphasize that, when Virginia issued the 401 certificate, Virginia thought that the water quality impacts were going to last days or weeks. Here, BLM has a new biological opinion based on the new hydrologic analysis that says impacts on sediment on streams will last up to 4 years. That's at JA 265. So it's drastically different facts than what BLM, the Forest Service, or Virginia Department of Environmental Quality considered back in 2017. On the hydrologic analysis, we are troubled by the agency's refusal to say anything at all about the USGS data. But even the information that they do cite doesn't support their position. And one of the issues this court remanded on in 2018 was the failure to consider or address the fact that mitigation measures don't work perfectly in practice. We have a demonstrated history of mitigation measures failing here. And the question of imperfect implementation or failing mitigation is not addressed by the model. So all the arguments about the model is good and the model is accepted have no bearing on the way they treat imperfect implementation. For perpendicular profiles where the pipeline is going up and down the slope, the hydrologic analysis makes no adjustment at all for imperfect implementation, even though the record shows that mitigation measures used there, water bars and sediment traps, often fail. I see that I'm out of time.
All right. Thank you, Mr. Matthews. Mr. Toth?
Mr. Chief Judge, and may it please the court, Brian Toth from the Department of Justice, representing the federal respondents, principally the Forest Service and Bureau of Land Management, or BLM. I'm sharing time with counsel for intervener Mountain Valley Pipeline, Mr. Don Barilli. Since this court last heard these agencies before the court on this project 3 years ago, the agencies have taken the court's remand order seriously. The court identified 3 issues on which it remanded and found flaws in the prior analysis. The agencies, in response, prepared a detailed supplemental environmental impact statement, or SEIS. BLM prepared a detailed practicality analysis under the Mineral Leasing Act.
Why was the decision made to skip over the pre-decisional review in, I guess, late last year in January this year and go straight to the undersecretary, who, at least for the record, I think there's some indication the undersecretary was involved, and I'm not sure it has to be, but it seems like he wasn't involved at all, too much, and yet went there and skipped over this pre-decisional review, which was undertaken, I guess, to some degree in 2017. Why was that done? Or was that something you think would be of any import to us?
The decision was made actually at the time the draft supplemental environmental impact statement was released to the public in September of 2020, not in January. And there was an opportunity for the public to comment on the undersecretary being the official decision maker.
But when you say not in January, I was referring to January 2021 when the
Correct.
undersecretary actually signed it.
Correct.
I wasn't talking about 2020.
No, so his involvement, there's documented involvement from the point of the draft supplement EIS, and that went out for public comment. In fact, the petitioners commented on that issue, and you see that in the record. So they had an opportunity to weigh in on that, and the Forest Service responded in the record of decision and in the response to comments as to why it believed that it was proper for the undersecretary to be delegated the authority and to make the decision without the pre-decisional objection process.
So the contention is that it really wasn't his proposal, it was a proposal of Mountain Valley Pipeline. But your contention is, I guess because of the review decision here, it indicates it is that it was the undersecretary who actually proposed it.
Yes, and I think you have to understand the nature of the proposal. I think I differ with my friend on the other side about that. They say that it's the privately conceived project that's the proposal. In actuality, the proposal was driven by Mountain Valley's application for a right-of-way from BLM. BLM in turn needed the concurrence of the Forest Service, which then needed to amend its forest plan. So this was a request essentially from the Forest Service to the public to have comments on the proposed amendment of the forest plan. That was an agency-driven proposal. It's true it was generated originally by the application by Mountain Valley, but proximately the need to amend the forest plan came from the fact that the Forest Service had to concur, or was asked to concur, in the right-of-way issuance. So I think that's supported by the text of the overall regulation. If you look at the second sentence of the regulation that we're discussing, 218.13b, it makes the undersecretary's decision final for the agency. I submit that that would not be possible under petitioner's reading. And in addition, there's just a common sense notion that the undersecretary being a sub-cabinet official, the highest below the secretary who supervises or administers a national forest, that he ought to have final decision-making authority, especially where the regulation.
So when you get to the issues that your opposing counsel was presented here, focus initially on the sedimentation analysis and impact errors. And to some extent, this whole business of the 15%, which comes from this measure of mitigation effectiveness measures, the question is whether what was used to compare that model, did it measure up to the effectiveness of what actually happened on the slopes of 15%? You got Jefferson National that has 15%, but the model probably doesn't take all that in. How does that factor in here?
So any model is going to have limitations. And the important thing under NEPA is that the agency acknowledges the limitations of the model, which it did, and then responds to additional concerns beyond that. So the agency relied on a thorough process of vetting the model and ensuring the integrity of the model, first of all, but it didn't rely on the model alone. It also relied on the fact that there were enhanced erosion control protections, in other words, best management practices over and above what the model had considered, and that it was requiring those in response to having reviewed this history of violations that my friend for the petitioners is referencing.
Well, Mr. Toth, you also maintain that it is, quote, unsound to force the sedimentation model into a real-world data point. How is the model an effective measure of what will happen in the forest then if it's not considering the real-world data points?
So the model considered other real-world data points taken from many years of data. It's a model that was developed by the USDA itself, the Agricultural Research Service, a liaison to the model's development.
Many years of data in the Jefferson National Forest?
No, elsewhere. But the point is that the model has enough data from other areas that it has been proven in the state of the industry and the state of soil conservation science to be statistically robust for its intended use. Okay, so it does have limitations. One of them is the steep slopes. That is why the agency didn't rely solely on the model. It looked outside the four corners of the model and it examined the history of violations that my friend is talking about. And you see this in the response to comments. I may have some page sites for you in a minute, but you have to look at not only is there enhanced erosion control protections that are imposed on top of the modeling, but also there is ongoing monitoring by a third party. You'll see this referenced in the record as the Transcon monitors. They were out there daily, giving daily reports during active construction. And since the project has been essentially put to bed for a little bit, there have been weekly reports as well on the stability of the slopes during this interim period. Where
so you say it acknowledged these limitations of the model. How did it acknowledge those limitations?
First of all, by reporting the results of the modeling and just fully disclosing the model and vetting the model through this essentially an interagency task force of 6 federal agencies, including someone from the Natural Resources Conservation Service, formerly known as the Soil Conservation Service, that looked at the use of the model and determined it was properly used within its limitations. Okay, those deliberations are throughout the record. I would point the court to the response to comments at 865 to 866 of the Joint Appendix. There are a number of other record sites of the deliberations that went on. I'll give you a couple. All 6 agencies participated in a conference call. It's summarized at 1666 to 1674 of the Joint Appendix. But over and above this, acknowledging the limitations of the model and that it was fully applied as intended, the agencies looked at.
What about the contrary data from the USGS monitoring data? What about that? Did it account for that?
So a couple points on that. The first, we have a little bit of tension in the record about specifically whether that data was considered, but there is a statement on page 579 of the Joint Appendix. It's in the EIS. It says all scientific information submitted to the agency during the public comment period was considered in the development of the FSEIS. So I think given the presumption of administrative regularity, you have to take that statement at face value and assume that the data was submitted, it was considered by the agency. There are some issues specifically on the nuts and bolts of the data, whether, it talks in terms of turbidity, which is cloudiness of the water, how that relates to sedimentation or where the dirt actually ends up is complicated. That is not the petitioners didn't make that connection. The burden was on them to do so. The gauge stations that measure these USGS stream measurements are located at some distance from the project site. So there's an issue about what was the weather that was occurring. Was this a storm event? How did this turbidity relate to where the sediment eventually ended up? It's a complicated process. And the best I can say is that for the many little things that like that, 1,000 cuts, I would say that my friend races against this project, the agency couldn't tackle them all head on. It had to focus.
Well, let me raise another one. What are the impacts of the conventional bore method for the stream crossings here, which I understand is different than what it was originally planned to be?
So it's expected that the under boring, conventional boring, will reduce the aquatic impacts and the impacts to the stream.
So I noticed you say it's expected there. The final consideration of what the actual impacts would be on the conventional bore method hasn't been completed yet, has it?
The NEPA analysis for the crossings on the national forest, there are 4 national stream crossings on the national forest, 2 that are nearby, so a total of 6 that were analyzed by the supplemental EIS here, which is what we're concerned about. Those were discussed in the supplemental EIS. Contrary to my friend's argument in the brief, there is more to it in the EIS. There's a number of citations for where conventional boring was analyzed. I'll give you. Is
there more left to be done on the conventional boring analysis by FERC or the Army Corps of Engineers?
It appears there is. I'm not representing those agencies. I don't represent FERC at all.
Okay. Why shouldn't we wait, or at least the agency wait until those reviews are done to actually know what the impacts of this new boring method for crossing streams in the forest would be?
Because those agencies' analysis is going to be more expansive. It's going to relate to nearly 1,000 stream crossings that are not on the national forest. I think my friend.
How many is it going to relate to that are on the national forest?
I don't know because I haven't seen that EIS. My friend just represented in his opening argument that those stream crossings on the forest are not at issue in these other proceedings before FERC or before the Corps. Plus 2 nearby, 6 at most. I mean, keeping this in perspective, there were 1,000 stream crossings that we're talking about in those other proceedings. Those conventional boring on those 6 stream crossings was discussed in the supplemental EIS. It's at 619, 676, 686 to 87, 712, 724 to 25, 752, 874. These sites are all in our brief. There are sites to the joint appendix, portions of the supplemental EIS where conventional boring was discussed. If I may, I'd like to address briefly the water quality certificate issue. This is somewhat clever of my friend. He originally raised this claim under NEPA, which is a procedural statute, but then when faced with the statute under the Clean Water Act that says, NEPA doesn't permit the agencies to second guess the water quality certificate, he resorts to these regulations that he calls substantive that apply to BLM. I'd urge the court to look at the text of the regulations. It's, it stems from the obligation of the Mineral Leasing Act to the Secretary to issue regulations or impose stipulations that shall include requirements to ensure that activities in the right-of-way meet water quality standards. There are stipulations to the right-of-way grant. Page 109 of the Joint Appendix, it's stipulation 38, says the holder must obtain all Clean Water Act Section 401's water quality certifications or waivers required for the project prior to construction on the national forest. That's for the whole project. And one more citation, JA 102, there's another condition that fulfills that statutory requirement to include the appropriate stipulations. See, I'm out of time, but I'm happy to answer any further questions the court might have.
Thank you, Mr. Toth. Mr. Verrilli, you have
Good morning, and may it please the court. I'm Don Verrilli for Intervenor in Mountain Valley Pipeline. I'd like to make a point about the forest plan amendment issue, the sedimentation issue, and the conventional bore issue, and if I have time, the pre-decisional review issue. But I'd like, if I could, to start with a broader point, a contextual point, which is that I think it's important to understand that we're talking here about a national forest, not a national park, not supposed to be kept entirely for pristine use in the way national park is. In fact, there are multiple uses. And the Forest Service not only authorized to allow for multiple uses, but is required by this applicable statute to do so. And I'm looking here at 16 USC 1604E, which says the Secretary shall assure that Forest Service plans provide for multiple use and sustained yield of products and services obtained therefrom. And I think that's critical because what it tells us is that there are going to be actions that occur in the forest that are going to change the ecosystem. And the question is whether the agencies involved taken a hard look at those actions and made a recent judgment in response, and they have here. And with respect to I'm turning first to the forest plan amendment issue, I think this goes directly to Petitioner's argument that the agencies didn't consider the effects of what they claim is an increase in sedimentation. I think they're wrong about those numbers, but whether they're right or wrong about the point is if the set pages 751 to 755 of the JA is where the forest plan amendment issues, they look with respect to soil erosion, all the different effects based on the information in the record generated about the level of soil erosion. They've come to the conclusion those effects are not inconsistent with the requirements of the Forest Service plan. So A, they obviously considered it. B, they made a reasoned judgment about it. That's all the law requires. By the way, with respect to this issue, those same pages clear up this argument, I think, that my friends on the other side make, that that the Forest Service applied the wrong standard, applied a substantial lessening standard instead of the regulatory maintain or restore standard. Every single one of those pages, with respect to every single one of the requirements of the Forest Service plan, you will see the agency applies expressly maintain or restore standard and then decides if the standard is met. With respect to, maybe you could just try to clear up the conventional bore issue quickly and then go to sedimentation. With respect to conventional bore, there was a thorough analysis by the agencies here of effects of conventional bore with respect to these.
So has FERC given final approval for the use of the conventional boring method here? And if so, where can I find that in the JA?
No, they haven't yet, Your Honor, but the question
Did you say they have not yet?
They have not yet, but the question I think the relevant place to look in the JA, if I could, is page 712 of the JA, which contains a very thorough analysis of the effects of conventional bore. We've quoted it at page 35 to 36 of our brief. There's a thorough analysis here that more than satisfies the applicable standard of review.
Well, I'm looking at JA 1201 where the FERC commissioner said, gave partial approval and said, while I approve the request to modify the proposed crossing method for these 6 streams, I do not authorize construction at this time. Construction remains contingent on other outstanding federal authorizations.
Right, but as respectfully, Your Honor, I believe the question before this court is whether the supplemental environmental impact statement was arbitrary and capricious for failure to consider the effects of conventional bore. And the answer to that is no. They were expressly considered. There's a lengthy paragraph.
Well, I guess my question is, it says construction remains contingent on other outstanding federal authorizations. That's what the FERC commissioner said. Have all those federal authorizations been received? You just told me that the FERC has not given final approval to use the conventional boring method.
No, they haven't all been received, but key point, I think, Your Honor, is whether
well, then how is that not arbitrary and capricious to just haul off and start construction when the FERC commissioner says that is not yet approved?
this doesn't allow them to haul off and start construction. The only issue before the court is whether this supplemental environmental impact statement is arbitrary and capricious for failure to consider the issue, and it did consider the issue. It can't start construction until FERC gives them the green light. That's a different question from the question of whether this SEIS is arbitrary and capricious. And that's completely answered by the material on page 712 of the 20.
Did 712?
712. It's completely
Okay,
answered.
thank you.
Lengthy discussion of effect. If I could,
I'll look at that.
turn to sedimentation, if I could. I think the key issue here is that with respect, I'm going to go right to this USGS data. Why it isn't a basis for finding the agency active. First, page 975 of the joint appendix, the agency does explain why it's not going to look to specific isolated data points, integrity of the model, the model's outputs in the question. Well explained there, and this is just one data point, and they've explained why they are not giving it considerable weight. And, that makes perfect sense if one thinks about it, because, for several reasons. First, it's an apples to oranges comparison. What the model does is evaluate expected annual levels of erosion. Turbidity readings would take 15-minute snapshots of what the water looks like at a particular day. B, there is nothing in the record, shows a causal connection between turbidity levels. It's complete speculation. They haven't cited anything. They cite 1191. We'll find they say nothing demonstrating a causal link between erosion and turbidity, and that shows you why. Does it make sense? Look at these kind of isolated data points and use them to call the model into question. And then another key point here, I think, that I think one can see this, it's quoted at page 30 of our brief, but the key point is that agencies didn't rely just on the model. They did look at historical experience. They explained that they looked at historical experience, and it's the key page there is 864 of the joint appendix. They specifically say, it's not just the model, that there is a robust system of monitoring, inspection, and remediation in place, and we have looked at the historical performance of that, which has led to substantial improvement. We can rely on that system so that if, to the extent the model fails to account for imperfect implementation of mitigation measures, they will be dealt with by this other approach. The agency took a hard look at it, specifically considered it, explained its results. So I see I'm over my time. If I am able to make one point on pre-decisional review, I would appreciate it.
You may.
Thank you. In addition to the point that my friend from the United States made about the nature of whose proposal it is, I would ask the court just to look at 36 CFR 218.1, which is the provision that sets forth the whole possibility of pre-decisional review. And it says pre-decisional review is available for proposed actions of the Forest Service. Their whole argument is that this proposed action isn't an action of the Forest Service because isn't a proposal of the Forest Service because it was a proposal by MVP. But if they're right about that, then the whole regime of pre-decisional review doesn't apply at all. Demonstrates why they can't be right about that and why the point the United States made about why this is actually a proposal of the Forest Service is correct. Thank you.
Thank you, Mr. Verrilli. Mr. Matthews, you've reserved some time.
Thank you, Your Honor. First, on the water quality standards, we consistently cited BLM's substantive obligations under Mineral Leasing Act 185 subsections H and J to ensure compliance with water quality standards. We did not hide that until the end. We cited it in our comments to the agency at JA 1027. We cited it in our opening brief at page 45. On the USGS data, Counsel for the Government suggests that maybe the USGS data isn't applicable here because it requires equating turbidity and sediment. That's post hoc, and it illustrates why post hoc arguments shouldn't be allowed. The method we used to correlate turbidity and sediment is supported by published peer-reviewed literature, and it underlies a good chunk of the biological opinion. It's what Fish and Wildlife Service did here.
So a major challenge we have here on review is we are bound by the record. And so when we hear argument of counsel pointing to various pages, you and your opposing counsel, the challenge to us is, that record may actually say that, but the question is the data there and is the analysis there? And that's a challenge for us when we're looking at this and trying to determine the words can be used, but then the question is, you take, for example, on 712, you talk about the conventional bore of a paragraph, in a paragraph, and it does talk about impacts. The question, and why these cases are difficult, is because they really get into the nitty gritty, so to speak. We all know the proper words and the way in which to capture it. The question is the data and analysis there in terms that supports this? And even when you talk about the criticisms of this data from USGS, the question comes up is, well, where are those criticisms in the record? Because argument is not going to suffice to be record alone. You got to have something to go with it. But those points have been articulated. Are there instances that you would think that there may be, at least to answer what you're saying, that boilerplate language is there, but what you may be pointing to is that the analysis or the data is not there?
That's exactly my point, Your Honor. And hopefully I can save you from work about wading into those details, because there is nothing there in the record here. The question isn't whether the agency... I don't
think you can save us from the work of wading into the details, because as I said, you don't have enough time to do that.
So on the USGS...
But we've got to do that, but to be able to point specifically, that was why I was pointing to the bullets of it. You probably should spend, as you heard Mr. Borelli point to direct points in the record. That's important to us because this is a record-specific case, and to be able to deal with it, we need to hear where in the record. I mean, we can talk about the policy and all the good stuff that can happen and why it's done, but when we leave out of this, what we're going to do is go to the record and then really dive into what's going on here. So that's helpful to us.
So I can't point you to where in the record the agency discussed the USGS data because they didn't discuss it. There is nothing in the record. If the agency had said, we aren't worried about this USGS data because we trust the model over the data for whatever reason, they could have said that in the record, and then we could have a conversation about whether those contentions were supported. But there is nothing in the record responding to this USGS data. Mr. Borelli pointed to, I believe it was page 712, which was the site. Mr. Borelli pointed to the manual for the model, which isn't any discussion of any technical expert here about the data in this case. And the manual says don't overfit to specific sites, but the manual also says don't just rely on the model, also consider on-the-ground data, as does Forest Service guidance that we cite on our brief. And the agency experts in the record here asked for on-the-ground data. So there's nothing in the record I can point to about the agency discussing the USGS data because they didn't discuss it, and that's our claim. On slopes, I just want to note that, although the model didn't include any explanation as to why its predictions were valid for slopes over 15%, in the national forest, more than half the slopes are over 30%. So it's a big gap. And then on the on the pre-decisional review, the 218.1 applies to actions of the Forest Service, and it's clear that it's an action of the Forest Service here. But it was proposed by MVP. Both the pipeline, but also the amendments were proposed by MVP. They've been steering the ship the whole time. We cite a bunch of places in the record where the Forest Service acknowledges that MVP proposed the amendments, not just the pipeline, in our opening brief at page 27. I see that I'm out of time, but if there are further questions, as you mentioned, Judge Wynn, I could talk about this all day.
Thank you, Mr. Matthews. Thank you all, counsel. We can't come down and greet you in our normal tradition of the Fourth Circuit, but know that nonetheless that we appreciate very much your being here and help on these very difficult and complex case. So I wish you well and stay safe. Thank you, counsel.
Thank you.
We'll proceed to our next case. Ms. Benson, you may proceed.
May it please the court, Elizabeth Benson on behalf of petitioners, and I'd like to reserve 5 minutes for rebuttal. As this court is aware, Mountain Valley Pipeline is a 304-mile pipeline that cuts across steep mountains and deep valleys in West Virginia and Virginia. The biological opinion at issue here estimates that sediment from this one project will impact over 1,000 miles of streams. Some of those streams are home to critically important populations of the two endangered fish at issue in this case, the Roanoke log perch and the candy darter. The Fish and Wildlife Service anticipates that the darter will be functionally extinct within 25 years. And a leading Roanoke log perch scientist informed the agency that any additional sediment loading is inherently problematic for persistence of log perch populations.
Let me make sure I understand what you're saying. You said it'd be functionally extinct even without the pipeline in 25 years?
Yeah, the Fish and Wildlife Service in their 2018 species status assessment runs various future scenarios, and the three that it considers most likely all end with the species being functionally extinct within 25 years, and that's primarily due to hybridization with another species.
So even without the pipeline, just so I make sure I understand you.
Yes, under all three likely scenarios, it will be functionally extinct, although the candy darter recovery outline has many goals to try to prevent that from happening.
Ms. Benson, that begs the question, how, if at all, this project accelerates or has a substantial impact on what you've told us as a rather moribund future for this species?
Yes, Your Honor. Well, where baseline conditions already jeopardize a species, an agency can't take action that deepens that jeopardy by causing additional harm, which is what this pipeline would do. So in the limited time we have today, I'd like to focus on the service's failure to analyze past, present, and future stressors impacting the action area, its arbitrary analysis of recovery impacts, and its weakening of previously established take thresholds without a reasoned basis.
So cabin this argument in a way that kind of breaks it down for us. This is something you guys do every day, and you use these acronyms as though the guy walking on the street uses them, but we don't. And so every time we do these cases, even though this panel probably, we've done more of these cases than many people, it's still something difficult to wade through. So you got two sections here, Section 7 and Section 9. As I understand, that's really where you're going with in terms of your complaint here on each one. So approach it from that angle, at least in terms of the law and how it's not being followed in this instance.
Sure. So the law requires that the service establish an environmental baseline to which the project's impacts will be added. And it also has to consider non-federal future impacts in the cumulative impacts section. The jeopardy analysis has to take that environmental baseline and those cumulative effects into account, along with the status of the species, when it makes its jeopardy determination. So it's supposed to analyze the past, present, and future impacts in the environmental baseline and cumulative effects sections or analyses. And then those have to be considered when it makes its jeopardy analysis. So basically, the service can't look at a project's impacts in a vacuum, because then any single project is unlikely to jeopardize a species. So turning first to the baseline, which is the effects of past and ongoing human and natural factors in the action area. Here, the record shows that factors already degrading the streams at issue are numerous: agriculture, logging, urbanization, mining, chemical spills, and so on. The BIOP provides no analysis of how these stressors are impacting the species in the action area, which is what is required, and doesn't consider those impacts in conjunction with the project's effects because it hasn't analyzed them, so it can't. For log perch, the service has advanced an argument in its briefs that a population viability analysis from 2016 somehow makes up for the BIOP's deficiencies. But population modeling doesn't mean the agency can opt out of this requirement to analyze the baseline and add the project's impacts to that baseline.
Why is that? I mean, what's wrong with the model? Why is the modeling not, doesn't that consider much of what you say is necessary, the cumulative effects and the baseline and at least the population. Why is that not sufficient?
Well, there are several reasons. First of all, it doesn't capture the baseline in 2020 because it's from 2016, and the regulations plainly require evaluation of contemporaneous actions, which we know are happening here and adding more sediment to log perch habitat. But by the service's logic, they don't need to analyze these impacts in the baseline. They can just continuously point to 2016 modeling and say that any given project won't make the population go extinct, which also conflates extinction with jeopardy. So, for example, in Oceana v. Pritzker, which MVP cites, the agency used a population viability analysis to inform its analysis, but it didn't use it to replace the baseline analysis. It had separately analyzed both the baseline and cumulative effects and then considered them in its jeopardy analysis.
Well, address the service. The service says that log perch and the candidata, looks like a candy, I guess that's why they named it, population models account for everything that's led to that current status and all potential stresses impacting the data. So what's wrong with that?
Well, for one, the viability analysis assumes constant environmental conditions over the next 100 years. So it can't possibly account for increasing threats like climate change. So the service's claims there totally fail, as do its claims regarding contemporaneous actions somehow being subsumed within this population viability analysis. It's also worth mentioning that Roberts, the author of this study, according to the BIOP, has said that log perch densities routinely fluctuate by more than 25% per year, and sometimes as much as 75%. That's at Joint Appendix 103. So depending on this estimate from 2016, which the viability analysis acknowledges has a lot of uncertainty in it, and really isn't meant to be used for this purpose. And a good illustration of this, again, is Oceana v. Pritzker, and also another case that used a population viability analysis, Turtle Island Restoration Network. They both ran the model with, first of all, they didn't entirely depend on the model, and they both ran the model as kind of the baseline with no change, and then with the project's impacts. So here, if you look at the jeopardy analysis in the BIOP for the log perch, the service analyzes the project's impacts in isolation, just exactly what it's not supposed to do. It analyzes them in a vacuum and then basically says, but this project isn't as bad as a catastrophe. Therefore, it's not going to make the population go extinct. That's not the purpose of a baseline analysis. It's an action area specific inquiry into the effects. And part of the reason for that is that understanding the baseline conditions in the action area is critical to understanding the impact that the project's additional sediment will cause. So if these species—
It seems to me as though you're really saying that the service is relying only on this model for this baseline and cumulative effects. Is that your contention? There's nothing else in the record they're relying on beyond that model?
For the baseline, they have a single sentence addressing that impacts in the action area include things like siltation and chemical spills and non-point runoff. That's at Joint Appendix 72 to 73. The environmental baseline section analysis is supposed to be analyzing those impacts. They don't say in the action area how those impacts, okay, siltation, for example. We don't know how those impacts are affecting the log perch or its habitat in the action area for this project, which is what its issue in the baseline analysis, because they just list the impacts and don't discuss they list the causes but don't list the actual impact. And therefore they can't consider them in conjunction with the project's impacts. And indeed they don't.
So that's the continual problem we have, as I said, in dealing with these cases. And I wonder, what is it that really you're seeking? If they say the magic words, we've done these things, and even if it's in a conclusory way, I mean, this is the service is saying it, is it your contention, you can say it, but if the analysis and the data is not reflected in what you're saying, it doesn't match up, or how are you approaching that?
So what the regulations and the case law and the services consultation handbook require is an analysis of the impacts. So yes, we're saying there's not magic words, but you can't just say, oh, there's some siltation and chemical spills in this area, but not have any sort of qualitative analysis of how that is going to be added, how the project's impacts are added to that baseline. And again, it doesn't account for any sort of increasing threat like climate change either. The BIOP admits the log perch is impacted by climate change, including increased turbidity, which this project will contribute to, but that's totally ignored in the jeopardy analysis with no explanation of why. So I'll move on to cumulative effects. So it was arbitrary for the service to rely solely on MVP's list of narrow list of projects requiring a state construction stormwater permit. The consultation handbook notes that the service can get information on non-federal future actions, which is what cumulative effects analysis requires, from a variety of sources, including inquiries during field reconnaissance in the action area and discussions with other agencies. And in past
so can the service rely upon Mountain Valley Pipeline for data?
I think it could have relied on Mountain Valley Pipeline if there had been a complete analysis, but this is just what Mountain Valley Pipeline provided was a tiny subset of projects. And the idea of the cumulative effects analysis is to understand the future context, how this species is going to find itself in the future, what's going to impact it. So MVP has acknowledged that there are other impacts. For example, in the upper Gauley River Basin, where the candy darter will be impacted, Mountain Valley said there were foreseeable trends demonstrating increases in agricultural activities, urban development, and road projects. That's the type of future activity that should be considered because it's part of the future context. And the consultations handbook provides an example that I think is highly relevant to our inquiry, which is that if there's a highway being built in a county that has a lot of natural gas development, future natural gas development is a reasonably foreseeable, is reasonably certain to occur in the future. So that should be considered. And in the past, the service has considered all sorts of activities like agriculture, logging, gas production, water withdrawals, urbanization, chemical spills, to establish what these future effects might be. And here it just relied on this one narrow list of projects requiring a state construction stormwater permit. And it didn't even include all the projects that would impact the action area, because it only looked at projects that are within 2 miles of the pipeline, whereas the streams are impacted miles away from the pipeline. So there could be a proposal for something right on the banks of the North Fork Roanoke River, but 4 miles down from the pipeline, where it's still being impacted by sediment from this pipeline. And that wasn't even taken into account, even in MVP's extremely limited list.
Don't the models actually consider the cumulative effects, or do they?
No, the models have inputs where they have assumptions about demography and life history, environmental variability, but as I mentioned earlier, they assume that it's constant. So they, again, like the environmental baseline, they can't substitute for this action area specific inquiry that the agency has to consider when it considers how this project will jeopardize the species. And since I'm low on time, I'm going to turn quickly to the incidental take statement. To measure take, the service said it was adopting harm thresholds that its Washington field office developed for bull trout consultations. And over the past decade, the service and the National Marine Fisheries Service have applied these thresholds in numerous BIOPs. And here, the service determined they were the best available methodology to assess impacts. But then it abruptly weakened these previously adopted thresholds making it less likely that the take limit will be triggered during a sedimentation event like a storm, which generally causes fluctuating sediment concentrations. And it did so relying only on a lay definition of part of a scientific term and without any scientific analysis of why these imperiled species that are extremely sensitive to sediment can withstand a weakened standard. With that, I see I'm out of town.
Thank you, Ms. Benson. Mr. McCardle.
Good morning, and may it please the court, Kevin McCardle on behalf of the service. I'd like to address each of those technical issues and try to help the court reach resolution on the baseline, climate change, cumulative effects, and the ITS. But first, if I may, I'd just like to say a few words on behalf of the career biologists at the service who spent the last year working tirelessly on this new biological opinion. They read the court's prior opinions in the Atlantic Coast Pipeline cases. They read them carefully.
Do those models, do they really consider the cumulative effects?
Here's what the models do and why they're so valuable and why actually they contain probably the best baseline information you'll ever see. The whole point of these two studies, Roberts for the log perch and the species status assessment for the candy darter, was to present an assessment of the present and future condition of the very populations that occur in the action area that accounts for all ongoing stressors, so that management agencies like the service can identify the specific populations of concern and come up with management strategies to address those concerns. So let's take the Roberts study for the log perch. What does that tell us? Why is it so valuable? Why does it present superior baseline information? Here's why. It tells us three critical things. It gives us a population estimate that's current about the two specific populations that occur in the action area and are affected by the project. Then it calculates a minimum viability threshold, which is the point at which a species has a 95% chance of remaining intact over 100 years. And it shows to land managers like the service that the populations here are well above that minimum viability threshold. They are, as stated in the study at 1625, numerically large and geographically extensive. Then they have 100-year risk projections to account for all stressors, including climate impacts. And even under those, and they analyzed a range of scenarios from anthropogenic human disturbances to see how those populations would respond in 100 years. And even
so let me ask you on this Roberts study, which is, it seems to me, as I recall it, it relied upon a 17-year data set from one population, and it made some assumptions on constant demographic and environmental conditions. And so to the extent that we're looking at this study in terms of how it dealt with this log perch population, why isn't it those assumptions didn't really take in consideration other factors that should have been considered?
Well, the 17-year data set is the best available data set, and the petitioners don't cite anything better that either the authors or the service could have used. The 17-year data set told us two critical things. It said, number one, there was no temporal trend in environmental stochasticity, which is just fluctuations in environmental conditions. So 17 years of data shows no temporal trend. And so my friend's assertion that, well, everything's going to get worse in the future, the data doesn't support that. We can look at 1614, it says there's no temporal trend, and that's the best data set. The second thing it tells us. So
you have this range-wide study. So how does it describe the baseline in the action area?
Well, it describes the current condition of the populations that occur in the action area and will be affected by the project. And look, the baseline is not some mysterious thing. All it requires is a description of the condition of the portion of the listed species in the action area. That's it. And what the service had here is the best you'll ever see. My opponent's right that in some cases...
Mr. McCardle, can I go back to what started this? Judge Wynn's initial question was whether the modeling here actually considered the cumulative effects or not. And I just would like to know yes or no.
Well, it projected forward-looking trends based on existing stressors and the best available data about anthropogenic disturbances. So that's what the service had. Now, how did the service account for cumulative effects?
Wait,
Well,
so is that a yes or a no? Did it, did it consider cumulative effects or not? It sort of sounds like to me you're saying yes because you're saying it considered this 17 years and the actual on the ground and then a 100-year projection. So that sounds cumulative to me, but I don't hear a yes or a no to Judge Wynn's initial question.
Okay, I'm going to say that's not exactly accurate, Your Honor. The way it's described in the BIOP is that it presents the present and future baseline conditions using the best available data. And it projects future trends based on ongoing stressors. What the cumulative effects analysis is looking for is much narrower. It is specific, especially when you have these risk projections.
Okay, so your answer is no, it doesn't necessarily consider the cumulative effects in the way that you typically think of it, but it's better than considering the cumulative effects. Is that what you're saying?
Yeah, it is better than what you'll see in any other BIOP because it's a quantitative assessment looking forward 100 years. But what the service was looking for then in its cumulative effects analysis is, hey, are there any specific future non-federal projects that are likely to occur, reasonably certain to occur in the action area that might cast doubt on those risk projections and require additional analysis? And so what the service did, it was relied on Mountain Valley's search of state permitting databases, stormwater permitting databases, and looked at the projects that that search turned up. Now, why was that sufficient? Here's why. But it captured any project that disturbs more than 1 acre of land, which is exactly the kind of project that you would expect to generate sediments that could accumulate with sediments from the project. So that was an appropriate search parameter. And there's another critical consideration. Remember that any actual in-water work would require, likely require at least, Clean Water Act authorization from the Corps, which would be a federal action that's excluded from the cumulative effects analysis under the ESA. And MVP noted that point at 906 note 22 in the record, and FERC actually noted that point as well at 1593.
So these projects, the only things that are happening in this action area?
No, there are ongoing stressors in the action area, and they are discussed in the BIOP, they're discussed in the Roberts study, they're discussed in the SSA, and they are accounted for in the population-specific assessments and risk projections in those two studies, which was the entire point of the studies. And they are incorporated.
And is climate change one of the... Go ahead, Judge Wynn.
No, I was just going to ask that it looks like the model assumed there were no floods, droughts, and did not consider the impact of the non-point runoffs, other things like channelization and things of that nature. So explain that. I'm trying to understand why they would assume those kind of things.
I would say that's not quite accurate, Your Honor. What they did was they came up with a term for their model.
So you're saying it's not accurate that they assumed no floods and they assumed no droughts and et cetera. You're saying that's not accurate?
That's not accurate. I guess it would be better to say they accounted for those types of events because they used a 17-year data set, and they say this in the study, and actually in the BIOP at 49, and at 1627 and 1617. That period of time they thought was appropriate to develop a term to capture environmental conditions looking forward because it covered the full range of population variability, and it also covered a period during which there were extreme high flow and low flow events. So that modeling term was appropriate to account for environmental conditions and include in the modeling. And by relying on that in its jeopardy analysis at pages 48 and 148, the service also accounted for climate impacts. Now look, could the service have been more explicit?
So you're saying the BIOP considered climate change with regard to the candy darter and the log perch?
Yes, indirectly by relying on the risk projections. But
well, that was going to be my follow-up question because I don't see the phrase climate change anywhere in the BIOP. So how do we know that it was considered?
Well, climate change is referenced in the BIOP with respect to the log perch at JA 49. It's not specifically referenced in the BIOP with respect to the candy darter, but it is in the service's species status assessment, which the service relied on throughout the document. So I think, Your Honor, this is a classic case where—
So is that what you were referring to? Is that one sentence that's in there?
Well, that's the one sentence where the service expressed its concern about climate change. What it's concerned about is not climate change per se, but environmental events like storms and droughts, exactly the type of things that the modeling in the Roberts study was designed to capture.
So where in the Roberts study is this climate change mentioned?
Sorry, Your Honor.
I'm just asking. I want to be specific. I think Judge Thacker and I are trying to understand that, because I said this is a specific thing, and I want to be careful because you say something, it's not the end of it. I mean, we go back and we listen to what you said, and then we go to the record and says, is it really in the record like that, or does it say that? And that's probably not helpful to you. I don't want you to get a negative reaction to something that you really could explain. And so I'm just asking, where in the Roberts study does it mention climate change? Because Judge Thacker pointed out the word is not in there.
Right, that's correct. The words climate change are not in there. They are in the biopsy.
So where does it even mention it? Anything about it?
Your Honor, this study was authored by 3 scientists in 2016. It's not that they were unaware of climate change. It's that climate change per se is not the concern. The concern is the consequences on the ground, the climate-related impacts, floods and droughts. And
so do I read that to say that it wasn't needed? You don't need to talk about climate change.
You need to account for environmental events. You don't need to specifically mention climate change. But, you know, this is a classic.
Isn't that kind of important? Because, in fact, we all know there's climate change. Isn't that a big deal in this? I mean, not living in a vacuum here.
Well,
so I mean, I'm just asking, is it, if I'm reading you correctly, you're saying, well, these are knowledgeable people, they know stuff and all of that, but I mean, we got to look at the record. And I'm wondering where in the Roberts study this is being accounted for. If your answer is it doesn't really matter, that's not something that's important, I don't know. But I want to be clear on your answer on it.
My answer is not that it doesn't matter. Ultimately, the answer may be that it's not all that important for the species, but it certainly matters. It's something that has to be considered. Everybody's aware of it, and no one more so than the 3 scientists who authored this in 2016. But the words climate change is not significant issue. The significant issue are storm events, high flow events. And the service itself said that at JA 49. They said that's what we're concerned about with respect to climate change, increasing storm events and high flow events. And those
so does the study include storm events?
Yes, it developed a term for its modeling.
You're saying the Roberts study included specific reference to storm events?
No.
Just want to be clear.
I don't know if it uses the word storm. Let's say that it doesn't, because I don't want to say something that's not in the record.
You did. That's why I asked. Was it in there? I mean, you used it.
The BIOP uses the word storm events. What the study uses they say it captured the periods of highest flow and lowest flow on record.
So I'd asked you earlier, didn't it explicitly reject flooding and droughts? The study?
No, I don't. Did it explicitly address or reject?
Reject. I thought I read it that now, again, this is your bailiwick. I'm having to dig into it. There's a lot of study got to be done for me here. But I want to be clear, because that's an aspect of it that sort of was a highlight to me. I thought I read that it rejected those things of floods and droughts. And if it didn't, then it just didn't. I mean, but I thought I read it.
I don't think that's a correct reading. I think I would look at JA 1617, where they say, we think these 17-year data set was appropriate to use for our term, our modeling to account for environmental stochasticity, because, quote, it encompassed some of the highest and lowest stream of flow events on record. So that's
I thought these are the words I read in there. We chose not to consider floods or droughts.
They chose not to consider them as catastrophes.
As what?
As catastrophes.
Where is that qualification?
Oh, it says it right in the study. I'm almost certain. I mean, it's got to be at the same page. They included a catastrophe scenario for human-caused events. They didn't include a catastrophe scenario for for environmental stochasticity, because the 17-year data set captured the full range of population variability and high flow and low flow events. And here's another critical factor. It indicated that log perch populations are not dramatically affected by floods and droughts. That's why it didn't use environmental stochasticity as a catastrophe, but it did include.
So now aren't you glad I asked that question so I could get that explanation?
Yeah,
but if they're not considered as catastrophes, then where are they included in the study?
Well, they say they developed a term to account for environmental stochasticity, which is these fluctuating environmental conditions, whether due to climate change, El Nino, or any other factor. And so that's what we're relying on. That's what the service relies on when they rely on these risk projections to account for climate change. And look, could the service have been more explicit and connected the dots? Of course. Of course they could. That's why this is an issue. I mean, as far as I can recall, we've been at this for 4 years and no one's ever raised climate change. It's raised here because they didn't explain it as clearly as they could have. But of course, there's a basic proposition of administrative law that this court itself, this panel itself, applied in the North Carolina Department of Environmental Quality case, where an agency's decision will be upheld, even if less than an ideal clarity, if its path can be reasonably discerned. And also the briefs we cited in our the cases, the Miller v. Lehman, the Missouri River, we looked at the record as a whole. And so, yes, the service could have done a better job here. But the critical thing is that—
Mr. McCardle, you rely on the 2016 study primarily, correct?
For the log perch, that's a key element, not an exclusive element, but a key element of the baseline.
That's why I said primarily.
I'm sorry, Your Honor.
I
agree, yes.
Is that a yes to my question?
Yes, yes.
And is it also true that the data for that study was collected in 2014?
That's when the 17-year data set ended.
Okay, right. So that was 7 years ago.
Correct.
It seems like you cite to a lot of potential problems, but how do you address that in terms of really have a meaningful impact on your assessment of the cumulative effect? To point to something alone is not enough, is it? Having pointed to it now, how do you really relate to that in terms of protecting these species? Shouldn't we know that rather than asking you all of these questions about where that is and trying to figure out what one page or paragraph is? Isn't that the gist of what we really need? You point to cite these things, but where's the analysis to point out how you incorporate them so you can protect our wonderful lands that belong to all of us as Americans? And your client has a responsibility to protect. Where is that accounted for? Can you point that? I know you have time, so you can just tell us where that is, because that's what I've been looking for. That's what we looked at throughout the record. So I don't want to ask you questions about what seems to be not even there. But tell me, where is it? Is it just thought pattern or where? That you actually address the analysis?
Sure, Your Honor. If I could take a minute and answer, I think there are two elements to your question. The first is a suggestion that maybe the data set was stale. And I'd just like to point out that the service also relied on the Roberts 2018 study, in which he essentially ratified the findings of the population viability assessment, and that's cited at JA 49. And then they reached out to Roberts in 2019, and they asked him, hey, are you aware of any increasing, changing threats or changes in the population status? And he said no. And he said, once again, the most comprehensive review of the status of each population was conducted by Roberts, the 2018 one, which ratified the 2016 study. That's at 1275. And this is a man, a scientist, who states around the same page, 1274 to 75, that he's performed multiple field and molecular research projects for 20 years and has recent range-wide experience. So the service did do its homework to try to make sure that these risk projections were still current and valid. Now, your second question, I think if I can just take a minute, I'll try to wrap that up. How did the service use this in analysis? They did exactly what they were supposed to do. They took these baseline assessments in both studies and they put them in the jeopardy analysis. At page 148, I think it is, in the jeopardy analysis is where the service discusses these risk projections. Because as we all agree here that the effects of this project can't be understood unless you have a sense of what the condition of the species is. And the service here had a really good sense based on peer-reviewed studies that they incorporated into the jeopardy analysis. And that's really the best that's the best that you can do. And it's more than rational. I see I'm out of time. I'm sorry, Your Honor. But if there's no more questions, I'll turn it over to Mr. Sibley.
So your basically your whole case relies solely on the quality of the studies that you rely on. Because that's basically what you're saying. We looked at the studies and we cited to the studies, and that's the basic, right? Because the analysis you said is baked into the study, correct? That's the only place we'll find all of your analysis is in the study alone, the four corners of it, correct? I just want to get that clear.
Well, I just want to be focused, Your Honor, because we did an analysis of a lot of things, the effects of the action. You know, there's a detailed analysis of the project's effects. So I don't want to say we just relied exclusively on the studies. So for the baseline component of it, we relied on the risk projections and population assessments in these two studies. And we also reviewed the ongoing stressors in the action area, which are defined for the log perch at 48 and 72 through 73. And also at 75 is where the service incorporates the detailed assessment of ongoing stressors from the SSA. So for the baseline component, these studies played a key role, like they should have. But that's not to suggest that that's the entirety of our analysis. I hope that responds to Your Honor's question.
Thank you. Mr. Sibley? You're muted.
Good morning, and may it please the court. George Sibley for Mountain Valley Pipeline. I suppose someone had to speak while muted, so I'm glad it was me. I'd like to start where Mr. McCardle was finishing, which is talking about the jeopardy analysis and how all of these, the environmental baseline, including an assessment of the status of the species, the effects of the project, and then cumulative effects all fit in. It's really a simple formula. Ultimately, you're trying to assess whether the action is going to reduce appreciably the prospects for species recovery or cause jeopardy. And the starting point is understanding the status of the species as it exists right now in the project's action area. You assume that those conditions are going to persist, you add the effects of the project to that, and then you add cumulative effects on top of that. And that provides the basis for making the scientific determination about whether the project is going to cause jeopardy. Now, turning to environmental baseline, I would note.
Let me see if we can unpackage what you just said. I want to make sure I understand that, because you seem to be claiming that the agency action shouldn't be considered together with the baseline and cumulative effects. So in effect, what that would lead to, seems to me, is that you could have, I think we had one of the species your opposing counsel said would be gone in 25 years, teetering on the brink of extinction. Due to the baseline and cumulative effects. And then the agency would take action that could kick it over the edge, but because that alone didn't lead to that jeopardy, that's not something that should be considered. Is that where you're going?
No, it's not. What I'm trying to explain, Your Honor, is how the project's activities, the project's effects are put in the context of what's occurring right now, and then added to what may accumulate in the future. That's the basic formula for the jeopardy analysis. And as Mr. McCardle mentioned, in this case, the agency had the ability, in understanding the environmental baseline and the status of the species, to rely on peer-reviewed scientific studies that specifically assess the status of these specific populations. Now, I'd note that my friend on the other side has made representations about how the Roberts study, for example, is only cited once. That's not correct. I think my friend is focused only on the section that's entitled environmental baseline without looking at the status of the species section as well. If the court looks at that section, you will see an extensive analysis and synthesis, not simply of the Roberts 2016 study, but the extensive line of work from Dr. Roberts and others studying what's going on with these species, broken out by specific population groups, in the Upper Roanoke and in the Pig River. This is perhaps the most robust set of baseline data that the agency can have to understand how the project's effects will add, along with cumulative effects, to potentially in making its jeopardy determination. Now, with respect to cumulative effects, I'd like to turn to the points my opponent made, that Ms. Benson made there. Now, first of all, it's no critique to say that Mountain Valley provided the information, that the applicant is supposed to provide data and analysis to the agency, and they did that here. And it's useful to remember that under the regulations, the regulatory definition of cumulative effects, activities that qualify are in a very narrow category. They must be future activities, so they're not ongoing or past activities. They must be non-federal. That is key here, and I'll come back to that in a minute.
And are you just relying solely on just these studies?
Yeah, and no, and I think there's two things going on here, and I think Mr. McCardle's in answering those questions, I think was resisting the conflation of two things. First of all, there's a suggestion that ongoing stressors were not accounted for. Now, ongoing stressors are not within the regulatory definition of cumulative effects. You assume in the jeopardy analysis that those are going to persist, and so technically you don't consider those in evaluating what are cumulative effects under the regulation. So it would be incorrect to say we're relying solely on the studies to look at cumulative effects. We're also looking to see whether there are future non-federal projects in the project's action area that would produce effects that would accumulate with the project's effects. Now, the fact that you're focused on non-federal activities is critical here because, as Mr. McCardle noted, anything that's going to produce effects within water or near water is almost certainly going to require some type of Clean Water Act permit. That establishes a federal nexus, and those projects will get their own biological opinion and be assessed independently. And you must look at effects that are likely to accumulate with the effects of this project. And those effects are sedimentation effects. And so naturally, you would look at construction stormwater permitting databases to see, is there anything planned, anything in the offing that we need to account for? It was rationally calculated to identify, to answer the question. The agency was more than reasonable in relying on it. I'd like to close in the time that I have remaining by focusing on calling the court's attention to just how seriously the agency took its mandate to exercise independent judgment. At every turn, indeed,
we're going to take it. We're going to take it. We can assume you took this seriously. I mean, it's a serious thing. But I want to ask you a question. You listed 6 construction projects for the cumulative effects. Is that all that's going on in those areas? Just those 6 projects?
Well, no. Certainly, you have activities that are ongoing right now, right? And when you're looking at cumulative effects, you're necessarily confined to activities that are reasonably certain to occur in the future. Now, you're already assuming that.
But I guess what, I want to make sure I understand your answer because I see where you're going. You got those 6 construction projects that are going on, and what else? I mean, you say there are other things, but where does the report account for the other things that are going on?
It accounts for it, as the report notes, in the status of the species and in the environmental baseline section. The report goes into great depth about all of the stressors that are affecting the species right now. And under the basic formula of the regulations, you assume that those things persist during at the outside 4 years of time that the project's effects will be felt in the area. That's the conclusion. And I would note, incidentally, that's one reason why climate change, there was an extensive discussion on that, is not terribly important in the context of this particular project. Of course, it's important society-wide, but the project's effects at the outside are going to be felt for 4 years. Climate change effects are much longer term in nature, so it's natural that you would not be as focused on that factor as you might be in some other types of cases where the project's effects would be more long-term. I see that I'm well over my time. If there are no further questions, I'll yield the floor to Ms. Benson.
Thank you, Mr.
Start with that last proposition of what does climate change do? Seems I don't know, I don't want to overstate what they said, but it seems like it's being minimized to the point that maybe it doesn't have the level of relevance that you would attach to it in the real world. What is your position on?
So the BIOP has one sentence on the log perch, climate impacts on the log perch. That sole sentence does admit that it's an increasing threat that causes impacts like turbidity. And indeed, in 2018, MVP has repeatedly complained that it was the wettest year on record, and that caused a lot of their sedimentation impacts. Well, that's exactly the type of impact that a climate analysis would help take into account. As for the candy darter impacts for climate change, the services species status assessment says there will be several climate impacts on the darter and that it's highly vulnerable to climate change. Those impacts include not just increased water temperature, but also altered flow conditions and increased sedimentation. And that's in the species status assessment. And these are species, both of these species, that are incredibly sensitive to increased sediment. So for the BIOP to not even mention climate impacts on the darter, let alone consider them in conjunction with the project's impacts, the court can't defer to avoid. I think the theory is, oh, just trust us, we considered it, but there's no evidence of that in the biological opinion or elsewhere in the record.
What about the status assessment that the service referenced?
Right, so it's the status assessment that says that the candy darter are highly vulnerable to climate change. And those impacts include increased water temperature, changes in hydrological conditions, and increased sedimentation. That's all in the species status assessment. It's never referenced in the biological opinion at all, and including not in the jeopardy section. And then as for the log perch, just to go back there briefly, as has been established, the viability analysis does not mention climate change, and its consideration of environmental stochasticity assumes constant environmental conditions. I think the service and MVP agree in the record.
Don't go by that word too quickly. I've been waiting for that to come up. Stochasticity. It's the only time I see it now. What's the problem with that? I mean, they account for a data differential as to what it actually is and what that model shows up there. So what's the problem with that?
The problem is it's based on outdated data. So their assumptions are for constant conditions over 100 years. We know that in reality, that's not the case, and the BIOP acknowledges it in its one sentence, calling climate change an increasing threat. So a study that assumes constant environmental conditions cannot incorporate or reflect an increasing threat like climate change. And again, we've already seen those impacts in the couple of years that this pipeline has been going. In 2018, it was the wettest year on record.
Is there a problem with assuming that environmental stochasticity would remain constant?
Yes, exactly. That's the problem is that it's not remaining constant, that it's increasing because of climate change. And as I said, the BIOP acknowledges that. It says climate is an increasing threat, which is something I think we all know. Just to go briefly back to the environmental baseline, yes, the BIOP mentions a few ongoing stressors in the status of the species section and the environmental baseline section. The problem is there's no specificity, there's no analysis. We don't know how these impacts are affecting the log perch in the action area, which is the relevant area for this inquiry. And the consultation handbook that service authored says you have to address the environmental factors affecting the species environment in the action area. I think they even underline it in a consultation handbook, in the action area. That is what they've failed to do here. And they can't possibly add the effects of the action to the baseline when they failed to establish that. Just briefly, in terms of understanding the status of these populations, Dr. Angermeyer, the log perch expert, who was another author of the viability analysis, along with Dr. Roberts, told the service in comments on this project that even incremental impairment of foraging can threaten population persistence. So just dismissing these impacts because they may not make the population drop below a minimum viable population threshold is inadequate. And I see I'm out of time. Thank you.
Thank you, Ms. Benson. And thank you, counsel. Again, we can't come down and shake your hand as we would love to do, but know that we appreciate you very much and help in this case. And we wish you well and stay safe. Thank you, counsel, very much. Would the court like to take a brief recess, or shall we move forward?
my presentation today. This case presents straightforward issues of statutory and regulatory interpretation as related to jurisdiction under the Contract Disputes Act of 1978. Consistent with that act, SATEC, a small federal contractor based in PG County, Maryland, sought contractual guidance from its counterparty, the United States Navy, as related to three discrete issues. Specifically, SATEC sought guidance from the Navy related to SATEC's agency status, the law applicable to its Navy contracts, and the allowability of certain costs under the Navy contracts.
So your action really is capping in the question whether there's even jurisdiction on this whole thing. By the way, I found that what your client does is some pretty interesting stuff. In fact, I wanted to spend more time studying that, but I know that's not in the record. But in any event, so when you're confronted with this situation, you've got California that brings up this law, and then, of course, as I understand it, you still have that case going on in state court now. Is that correct?
Yes, Judge.
So with that matter going on, you then seek to come under the Contracts Dispute Act in order to, I guess, get something that looks like a declaratory judgment, but something like that. You want a declaration as to, if I'm gonna have to pay this money, is the Navy gonna pay me? But you can't get there if you're talking about money and you don't have a sum certain in there. So if that happens, then I know 1 and 2 and 3 are counts are gone. And then you don't get there if if the right isn't dealt with on count 1 in terms of the final agency. So if those things all exist, we stop right there. That's kind of where the district court went with this and made a determination. You're talking about money here. And that's probably the first hurdle you need to deal with, I would think. But you approach it however you want to, but it seems like jurisdiction, as in everything we deal with, if you don't have subject matter jurisdiction, there's no need to talk about anything else. And that Contracts Disputes Act is there for a specific purpose. And there are a bunch of cases. Now, admittedly, I'm gonna tell you, they're all over the board. So I'm expecting some confusion to come from your answer right now, because I can't even be clear on it. But it looks like to me that's pretty strong, strong indication it could be at least 2 and 3. The council, that's money you're talking about. How do you respond to that?
Yeah, and I think it's important, Judge, to first start, as the district court actually did, by taking the agency issue and putting it to the side, and then let me address the two, what I'll call the two Mendiola issues. And I want to start by saying that this is a false distinction. I agree that it sometimes creeps into the law and you can read it this way, but if you step back and you look at the Contract Disputes Act and its implementing regulation, FAR 33201, 52, FAR Part 52 233-1, in the definition of claim, which also appears at FAR 2101. By the way, the FAR is all codified at 48 CFR. But when you step back and you look at that, there are actually 3 types of claims that can be filed under the Contract Disputes Act. There is a monetary claim that has a some certain requirement. And what you've expressed about that monetary claim, Judge Wynn, is indeed correct. It has to have a some certain, and it has to be certified. That's one category of claim. There's another category of claim specific in the regulation that you're allowed to bring that asks for an interpretation of contract provisions. Then, when we're looking at 52 233-1, or whether we're looking at FAR 2101, the 2 places the definition of claim appear, there's an or, the word or appears, and then it says any other claim related to or arising out of the contract. And in fact, the Federal Circuit has spoken to this issue pretty clearly, and I believe most clearly in Todd Construction and Alliant Tech Systems. And first of all, in Todd Construction, the Federal Circuit said unequivocally that this is broad jurisdiction, right? in an Alliant Tech Systems.
Isn't the practical effect of what you want the Navy to answer is whether or not you can get money from the Navy if you settle?
Absolutely not, Judge. And I think that this is how my opponent was able to distract the district court on this issue, was to make that argument. But I've just challenged the court to think about the two things that we're talking about here, the two Mendiola related issues. And let me just make sure the court understands very quickly what happened in 2015. I'm not going to spend much time on this because I know you're probably familiar.
I think we do understand what happened with the change in the law and all of that. And now you want to figure out whether you should pay or not pay for the sleep time, which is why I asked you, isn't the practical effect of this whether or not you can get money back from the Navy if you do end up having to pay for that sleep time?
No, in fact, it's not at all. It's just for us to know what the Navy's position is on the law, Judge. And this is why, if you actually look, SATEC brought this issue to the United States Navy before. It was a diligent contractor, a diligent small contractor brought this issue to the United States Navy before it was sued. It saw the Mendiola decision.
And why does appellant want to know what the Navy's position on the law is?
Because if the Navy, Judge, if the Navy says that federal law, as the U.S. Supreme Court said, disagreeing with the 9th Circuit, by the way, I mean, to show you the complexity of this issue, the Supreme Court in Parker Drilling dealing with the Outer Continental Shelf on Mendiola disagreed with the 9th Circuit on the applicability of law, said federal law applies on the Outer Continental Shelf. SATEC understands that if the Navy says, look, we believe that federal law governs Naval Base Ventura County and our Navy ships when you're out supporting them, not Mendiola. SATEC knows that if it goes, that it, in the litigation and otherwise, I mean, outside litigation, in the litigation, it knows the Navy's position. So if it goes and settles the case, it may get whacked by the Navy saying, why did you pay something that wasn't due, right? And in fact, if you read the government's briefs, and this is what's so interesting about their arguments, Judge, that this is about money. No, it's not. In the government's briefs, it repeatedly intimates, as its lawyers said prior to us bringing this claim and prior to SATEC getting sued, that Mendiola does not apply.
But they're not gonna, the Navy's not gonna ask, why did you pay the claim, until you ask for some money from the Navy.
But this is a trick box.
You can pay the claim all day long, but if you don't go and ask them for the money, that's what it's about. You want to know, if we pay this claim, that's part of one of your counts in there. If we pay it, are you going to give us our money back?
We have to understand on the legal issue, Judge, what the United States position is, so we know whether in the lawsuit and in other circumstances with our employees, whether we should be paying this Mendiola wages or not paying the Mendiola wages, whether we should be fighting litigation, not fighting litigation. We need to know the position of our contractual counterparty. The answer, quite frankly, the answer they gave before we got sued, before the small business got sued, was that Mendiola did not apply. And if Mendiola, they were saying, don't you dare pay. Don't you dare pay. So in response to Judge Thacker, the answer does not mean if they say, don't you dare pay, that this was a money decision. This is as pure as you can be on a legal issue. What law do you, Navy, believe applies to this contract? And their likely answer is going to be, in my estimation, based on what they've suggested and otherwise, both prior to the lawsuit, is that Mendiola does not apply. So absolutely, this is not a question about money, Judge. If they say that, there's no money that inures to my client. It answers a basic proposition that we have to know as the United States Navy's counterparty. What do they think about Mendiola applying? So we can make reasoned decisions relative to defending litigation, running the contracts day to day, etc. There's no money.
So you got three claims, three counts.
Yes, Judge.
And I'm looking at count 2 and 3. I could probably understand where you're saying count 1 may not be that monetary thing, but count 2 goes back to Judge Thacker's thing, and that's dealing with, having to pay this money. And you want to know, essentially, from the Navy, how does this relate? Do we have to pay this overtime and other compensation under this? And then count 3 says, if we settle this thing, is that going to be cost that you're going to give us under the contract? Why is that not money? That's money.
But Judge, here's the thing. This is a false distinction that I don't think is borne out actually when you look at the Federal Circuit decisions or otherwise. They dealt with this in Alliant and Todd. If you look at the Armed Services Board of Contract Appeals decisions in TRW and Martin Marietta, they are whether or not costs are allowable under the Federal Acquisition Regulation. Indeed, this is the trick box they put us in, Judge. If you go look at the Federal Circuit's decision in IT&T and Raytheon, both cited in our briefs around page 50, the Federal Acquisition Regulation says that a diligent contractor, if it is going to incur an unusual cost, this is 48 CFR 31109, should approach the government and get its position on allowability before it pays the amount. Why? Because the contractor is not expected to go into an unusual situation and be at risk. That's right in the CFR. And indeed, what the Department of Justice does, Judge Wynn, if you go and pay without asking, look and see in IT&T and Raytheon. What did the Department of Justice say? Hey, contractor, you had an unusual cost. You never should have paid this without coming and asking us. And if you look at
you realize how many times you've said the word paid and this, I realize where you're going with what you're trying to say, but on the one hand, it's almost like a fiction. You want the Navy to tell you what it thinks the law is, which wouldn't be binding on anything other than maybe you could come back and try to say it maybe it's outside the contract. This is influencing our terms of the contract. That's not going to work. But you want to say, okay, just tell us what you think. But you don't have to pay us anything. You don't have to obligate that we're not talking about money that you will pay us. Just tell us what you think the law is. And then, but I'm that's why I'm hinging on this 2 and 3 more so than 1. It looks like to me is money. And even in your explanation, I know where you're going with it, but the word pay and money cannot, it keeps coming off your lips.
But Judge, this is why it's critical for you to understand what I'm saying, which is that there are 3 different types of claims, right? And it is a false proposition that if your claim has anything to do with money, it is invalid unless it's got a some certain. The Federal Circuit has rejected that point that the government is arguing. It is, if you look at TRW and Alliant, these are cost principle cases. The exact circumstance I'm talking about here, there are 3 types of claims. That's one of them. And there is no, just to be clear, there is no, when we ask, will you treat the cost, the settlement cost, as allowable to recover money under the Federal Acquisition Regulation, your cost needs to be reasonable, allocable, and allowable. When you ask whether something is allowable, that's a specific, what is your legal position? Do you agree that if this cost would be appropriately claimed by us? And not only does the FAR allow us to ask that question under the CBA, under FAR Part 31, the FAR tells us a diligent contractor asks and gets the answer to this question before it pays. Because, if you go out and pay, Judge, as I told you, look at Raytheon and ITT, you go out and pay an unusual cost, they deny it. In the court, the first thing the Department of Justice says to the court is, why didn't you get our position?
Do you want to address your first claim at all before your time runs out?
Sure. On the agency issue, again, look, probably the clearest thing we can look at here is that the Department of Justice, in this case, issued a letter, sent it to the unsolicited to the plaintiffs in the Richard action, interpreting the contract and saying that we were not agents under the PVA and SIA. There is one authority that we can come to challenge that assertion made by the Department of Justice on the Navy's behalf. We can come under the Contract Disputes Act to applying the PVA and the SIA is how I get into district court, by the way.
What about the prudential issues, given the fact that the California State Court has said otherwise already in the ongoing litigation?
Well, first of all, there is no prudential issue from my perspective, in the sense that I think Lexmark raises questions about whether that's an appropriate approach or appropriate vision of this. But from a separate, leaving aside whether or not where Congress has granted jurisdiction, whether the court could prudentially deny that jurisdiction, something that Lexmark says is not possible. But leaving that issue aside, the reality is on that particular issue, there is one court that is authorized to determine whether or not SATEC is a PVA and an SIA agent as a matter of U.S. code law. And that is the court that has jurisdiction over the CDA claims. The California court doesn't get to declare the rights as between the United States and the Navy under the Navy's contracts. Congress gave that direction to follow the CDA to get that analysis. And indeed, in TRW, the Armed Services Board of Contract Appeals found that it would be inappropriate to stay this type of case based on the fact that there was some other jurisdiction looking at the matter. That we have a statutory right, and this is the only place we can be to get the answer to this question. Thank you, Judge. I reserve the remainder of my time.
Thank you, Mr. Holman. Ms. Murphy.
May it please the court, Anne Murphy for the United States. Your Honors, I just want to read the claim, which is at page 51 to 52 of your joint appendix, so the second and third claims. It literally says that SATEC wants the Navy to confirm that it, quote, will reimburse the charges as an allowable cost under the contract if SATEC makes a settlement. And to confirm—
But does it matter that SATEC is really saying all it's doing is following the Federal Acquisition Requirements Act in terms of that if you don't do that, then you won't be able to maybe get reimbursement and other things of that nature. So it's just doing what the law tells them you got to do.
Well, Your Honor, that's not true. I mean, they say there's three types of claim, and therefore they can kind of bring any claim they want. But as the district court said, the point is that if your claim is actually a money claim, that's what it is, and you need a sum certain. So the Federal Circuit and Security Force said, something very relevant here, which is that if you have a monetary claim, you need to have that sum certain, and you can't just go to court saying, oh, well, it's, I do want money at the end of the day, but this is just for relief arising under the contract. The district court was absolutely right. These are monetary claims. There's no sum certain.
He says they don't want money at the end of the day. They merely want to understand the Navy's interpretation of the law so that they can make decisions on a daily basis going forward in this California litigation. What's your response to that?
So the answer to that, Your Honor, is that we do not know what law governs these employment contracts. And the California court is deciding that. That's a question that's pending in that court. They've already said no to the Suits and Admiralty Act, as Your Honor pointed out. We don't know, and SATEC comes and it asks a contracting officer, what do you think the law is that applies to our employment contracts? And that's why this is such a difficult suit to deal with. It's like we have no way of knowing what the law is.
So it wants the Navy to basically give it Exhibit A in its California litigation when the Navy's not involved in that litigation and just can't answer that question right now.
That's exactly right. And that's what the district court pointed that out too. It said that even if there was some judgment, in this case from this court, it wouldn't actually help SATEC get relief from the insecurity in the California action because, as you point out, the Navy's not a party to that action. We don't have any influence over what happens, and that court's going to do what it does. And at that point, Your Honor, I really do want to assure the court we are standing by to adjudicate any proper claim that SATEC ever has. As counsel said, under the Federal Acquisition Regulation in a cost reimbursement contract, which this is, the Navy is required by law to only reimburse those costs that are reasonable, allocable, and determined to be allowable.
What should SATEC do here? They've got a contract. Then you get a law in a state, California, that says you got to pay your people even when they're sleeping. if you have certain control over them, it necessarily changes the terms of the contract in terms of what they had did it from an economic. And but what, is there some other avenue other than the Contract Disputes Act that they could pursue? It seemed like they tried a lot of different avenues, and then finally came to this one. And you know, I guess the Navy as an agency, I mean, separate could send certain officers and reports to it. I don't know if they want to take that on or not. It's kind of interesting. I don't know who does it. I guess the Navy contracting people do it, not the Navy itself, because this is money you're talking.
Right. I mean, we understand that this is very hard for a contractor. And if we,
well, how can they find this out? I mean, it seems like fundamentally, if you're going to have a contract with someone and then the state changes the laws of something, is it just tough luck? You know, that's you just going to have to bear what the state did, or wait until it happens and you pay it, then submit it, and then we'll have the. And maybe that's it. What you're saying is ultimately you just got to go ahead and do it, and then seek to see if you can get payment for it through an avenue other than Contract Disputes Act. Is that right?
There's a couple of points here, Your Honor. One is the most recent iteration of this contract was negotiated in 2018. At that point, SATEC knew that the Mendiola litigation was pending, and it knew that it had been sued by its employees. So from that perspective going forward, SATEC could have given us a higher cost estimate to reflect the litigation risk. It didn't do that. Since it's a contractual relationship and it's constantly evolving and being renegotiated from times, going forward, SATEC can protect itself by increasing its labor costs that it submits to the Navy. So that's one thing. On the other thing, the answer is it is a cost reimbursement contract. And if costs increase in California because of a change in California law, and it's not addressed in our contract apart from we will reimburse reasonable allocable costs, SATEC really does have to litigate or settle, or counsel was talking about the procedure for making an advance agreement. Notably, Your Honor, they talk a lot about that, but that's not what they asked for here. They didn't come and say, Navy, you know, please will you negotiate with us? Can we get an advanced agreement? We want to settle this case. Here's what it would look like. They just want this blanket declaration that if they settle, will it be allowable costs? Like
how would it ask that? You mean outside of litigation, just come as a matter of policy to go and ask the Navy? It tried that. It's what I remember. And got stonewalled. You couldn't get anything from the Navy, and couldn't get them to commit. And you know, you sent a letter and basically said, hey, you know, that's interesting. First, it looked like to me they were in, then they kind of backed down. You know, that happens sometimes when you change up people. You back down and decide, you know, I don't want to talk about this right now.
Yeah,
so I don't know if that was open to them as an avenue to go and say, well, you know, we got this coming up here. You know, why don't we renegotiate this? Was that available?
There is, and it's at 48 CFR 31.109. There is a procedure whereby if you think you've got an unusual cost coming up, you can go and talk and see if you can have a meeting of the minds. It's not totally clear here because these costs are just costs they have to incur anyway, but let's say that they could. They have not done that. And in order to get those costs approved, they would have to be specific. They would have to say, here is the settlement. Here are the claims we are settling. Here are the contracts they belong to. And so that's what we don't have here. We have no idea because there are no additional costs yet. We don't know what they would look like. We don't know what law the California court's going to apply. We don't know if it's going to think they're like little federal parts or California parts. And until we have some clarity, or until SATEC even brings us like, here is what the settlement agreement would look like, and a very detailed thing that we can talk about, we literally are not permitted by the FAR to give it some declaration that whatever costs it incurs, we're going to cover it under this contract. We just can't. On the
question of whether this is monetary or non-monetary, does the federal circuit case Secure Force hurt or does it help your case?
Oh, it helps us. That's our best case, Your Honor. It just says if you have a claim, it rebuts the argument that, you know, there's three kinds of claims, so you kind of take your pick. What Secure Force says is there's three kinds of claim, but, you know, if your claim is actually a monetary claim, then you have to have a sum certain. You can't say, well, I don't have a sum certain, but it doesn't matter because I'm actually just asking for an interpretation of contract terms.
Well, I mean, that even if you can find it, count one and count two, you wouldn't be able to get there in terms of calling asking the agency, the claim of agency as being monetary, would you? That you agree to that? That's not monetary, is it?
We agree that that's not monetary. The problem with that one is it's not even really a claim. It's like, so just let me, if I can just back up a little bit here, Your Honor. The Suits and Admiralty Act and the Public Vessels Act are waivers of sovereign immunity of the United States. They do not create generic agency relationships such that, you know, people run around being agents of the United States. The way they work is that if there is an incident and litigation arises, the Daniels case, which is talked about here being typical, a seaman was injured on a Navy vessel while SATEC was operating it. In that situation, if SATEC is sued, it can say, listen, this should really be a suit against the United States, not against me. And then it can ask for the United States to be substituted as the defendant in that litigation. It is highly fact specific. For example, if the seaman's injured at sea, maybe he's on a Navy vessel, that's an easier case. But maybe it's one of these cases where under the contract, SATEC can go and hire a private vessel and use that. In that case, we would probably say, no, that's not, you know, you can't substitute the United States. SATEC might disagree. Or say there is a Navy vessel, but actually the negligence that led to the accident had nothing to do with the condition of the vessel or the United States, and it was something that SATEC did. So these are very fact-specific issues under the SIA and the PVA, and there isn't this just generic agency floating in the air. And so that's why that claim isn't good. And as the district court pointed out, you know, you have to have something that you're actually entitled to under the contract to get a declaration on it. And any order that this court were to issue under the SIA or the PVA would just be, you know, relevant to whether in litigation the United States could be substituted as the defendant.
Does it matter that SATEC seems to operate some non-Navy ships, at least under the contract provision? Some of the cost receipts indicate that. Is that they seem to operate non-Navy type ships?
Yeah, as I just said, that would be relevant under the Suits and Admiralty Act and the Public Vessels Act, because if it's a Navy vessel, we know it's a public vessel. If they're operating a private ship, we would take the position that at least at the outset, we would definitely take the position that that was not a proper Suits and Admiralty Act case. And you know, I'd just like to point out that at page 19 of their reply brief, they tell us what we really want to know is the United States the proper defendant in the Richards case, which is the California case? And the California court has already looked at this issue and said no. At page 100 of the JA, it went through a laundry list of reasons, like there's no claim against the US, there's no identifiable federal interest or policy, nobody was injured on a federal vessel. It's just a state law breach of contract action based on the California wage laws. Notably, that letter does not say anything about DOJ, that decision doesn't say anything about DOJ representations. It's just the court goes through and applies the law and talks about the Suits and Admiralty Act and says, this really has nothing to do with this case. And that's where it's relevant. And I think at page 19 of the reply brief, that's where SATEC finally buckles down and says, yeah, we really want to know about the Richards action. So, Your Honor, I think that's all I have for you. If you have further questions, I'd be delighted to address them.
Thank you, Ms. Murphy. Mr. Holloman, you have some time reserved.
Yes, thank you, Chief Judge Gregory. I'm going to try and just hit a few of those points that I think are important. First of all, the suggestion that SATEC didn't present or seek an advance agreement on these costs under FAR 31109 is completely inconsistent with not only the communications with the Navy, but also the certified claim we submitted. And I've got to be a little bit careful here because, you know, quite frankly, I'm nothing short of stunned to hear Ms. Murphy present to this court that we have never provided any indication of what it would take to resolve this case. Indeed, that has been done and presented to her office, and her office refused to act on the putatively agreed to resolution. So the fact that the United States has told this court that if they just had an idea what the money was and what the issue was, it would answer the question is simply patently false. Now, turning back to the PVA and the SIA, I note that what Ms. Murphy did was frankly spend a bunch of time arguing about what? The merits of this case. Indeed, whether or not the court ultimately, the district court ultimately should find us to be an agent or not an agent under the contracts is not a jurisdictional question. It simply is not a jurisdictional question. That's something that the court would take up, consider all the evidence that's in front of it. But I want to make sure that I point out that when Ms. Murphy says all that factual detail is necessary, I strongly encourage this court to look at JA-39 and JA-40, a letter from the United States Department of Justice to the plaintiff in the Richard litigation that spans all of 2 paragraphs, never mentions any of the things that Ms. Murphy says are necessary to analyze whether somebody is a PVA or an SIA agent, and not only says that we are not a PVA and an SIA agent, but actually affirmatively says that SATEC and CPC may not make any such representations to the contrary. So indeed, they issue a letter that does none of the things that Ms. Murphy has said, interpreting this contract of saying we're not a PVA and SIA agent. And indeed, this does end up in front of the California court. And unsurprisingly, the California court finds that we're not a PVA and SIA agent. But at the end of the day, as I said, and is clear under the Contract Disputes Act, and it's clear under our contract, whether the California court considers whether or not we are an agent under these contracts as determined by the appropriate authority that Congress has identified. Whether the California court considers that is the California court's business. But what I'm here saying is the United States has made an affirmative statement about our agency status, an affirmative official statement about our agency status, that we are absolutely entitled to have heard, whether it's correct or not. And if the United States meant all the things Ms. Murphy said, it would have retracted that letter a long time ago. But instead, like everything it's done in this case, it's cut SATEC loose. It told SATEC to not to follow Mendiola. SATEC got sued. The Navy cut him loose. Now, if you read in the joint appendix, you see the very communications where the Navy acknowledges that this is a big issue for the Navy. It's much bigger than SATEC, right? And they acknowledge that in their emails with SATEC that are in the record. And the answer from the Navy is not to defend their contractor, help their contractor, tell their contractor the position. They cut their contractor, a small PG County company, loose to deal with a multi-million-dollar class action without any guidance from the Navy. And then on top of it, to make sure they were not dragged into the suit because they didn't want to be there. Let's be clear about it. Because this is a big issue for the Navy, they said it right in the emails that are in your record. Instead of doing the honorable thing, they sent a letter to the plaintiffs in the case saying we're not a PVA and SIA agent, and you know what? They can't even represent that. And the fact that the suggestion is that the Navy, having done that on a matter of agency, having made an assertion through the department of that nature, that we can't have our case heard about whether that statement, official statement by the United States, is correct or incorrect, is simply wrong jurisdictionally. And whether or not Ms. Murphy wants to argue with me at a later date in district court about whether or not we actually are an agent is not before this court. The question before this court is, have we brought on a proper CDA claim? And very quickly, Secure Force, there was no claim, if I might, Your Honor, I see I'm a little bit over, but just very quickly on Secure Force, there was no claim at all by the plaintiff in that case. That was a termination for default. The places to look for similar circumstances are cited in our brief: Alliant Tech Systems, Todd Construction, both Federal Circuit cases, TRW, Martin Marietta, both cost principal cases. The Secure Force is not applicable to this case. There is no termination for default. There is no government claim. And in that case, there was no claim filed at all. We obviously did. Thank you very much. We appreciate your time today.
Thank you so much, Mr. Holman, Ms. Murphy. We can't come down and greet you, but please know that we appreciate so much your helping us on this case and your presence. And we wish you well and be safe. Take care, everybody. Bye-bye.
Thank you.
Good morning, Your Honors. At issue in this case is whether Mr. Hope's prior conviction.
I'm sorry, I don't see the other counsel on the screen.
Mr. Patel, Mr. Booth is here now. Thank you. All right, Mr. Patel, you may proceed.
Sorry about that. So, Your Honors, at issue in this case is whether Mr. Hope.
Mr. Patel, before you go any further, you're either breaking up, but you're fading in and out. You need to get closer to your audio source. It's better, but it's not a good connection. Go ahead, start.
Your Honor, at issue in this case is whether Mr. Hope's prior South Carolina convictions for distributing and possessing with intent to distribute a controlled substance within 1/2 mile of a school or park qualify as serious drug offenses under the ACCA. They do not, because the school and park proximity statute is overbroad and indivisible by drug. Now, the parties agree, Your Honors, that the statute is overbroad because it criminalizes more drugs than does the Federal Controlled Substances Act, cross-referencing the ACCA. So the only dispute here is that the proximity statute is divisible.
I'm sorry.
Ms. Patel, we have a Mike. Would you stop the clock, please? Thank you. Mike, can you help us to see whose end that is? And because it's going to be untenable going forward like this.
I'm really sorry, Your Honor.
No, you don't have to apologize. We got our technical staff. We're looking at it now.
Yeah, Mr. Patel.
Okay, I'm so sorry, Your Honor. Do you want me to start over or should I just keep?
Well, I'm not sure. Hard to hear you. Why don't you start over for the sake of just safety? Go ahead.
Okay, I will, Your Honors. Okay, so Your Honors, at issue in this case is whether Mr. Hope's South Carolina convictions for distributing and possessing with intent to distribute a controlled substance within 1/2 mile of a school or park qualify as serious drug offenses under the ACCA. They do not, because the school and park proximity statute is overbroad and indivisible by drug type. Now, the parties agree that the statute is overbroad because the statute criminalizes more drugs than does the Federal Controlled Substances Act, cross-referencing the ACCA. But the only dispute here is whether the proximity statute is divisible by drug type. And on this front, Your Honors, the government has failed to meet its very heavy burden of proving with certainty that the statute.
Before you go too much further into the substantive argument, I really need to know why this is not plain error review, since it was not objected to below.
So, Your Honor, two things. The plain error review should not apply here, and I'll explain that. But even if plain error review applies here, the government still hasn't met their burden. But the reason plain error review does not apply here is because the claim is one and the same as the claim that was raised below. The claim is that the proximity statute fails to qualify as a serious drug offense because there's a categorical mismatch.
Right, but the argument made below is wholly different than the argument being made now. And isn't the whole point of requiring somebody to object in the district court to give the district court an opportunity to address the argument in the first instance?
Well, Your Honor, under E versus Oscondito and U.S. versus Robinson, de novo review should apply here because yes, the arguments did vary, but they were in support of the claim here. So the argument below was that there was a categorical mismatch because the statute brought an indivisible and criminalized purchase of drugs, which is so on appeal, we continue the categorical mismatch argument, but for a different reason. Does the statute criminalizes drugs? More drugs than does the federal controlled substance.
I can't hear, I'm sorry, I can't hear Mr. Patel really at all. I don't know if we should have him log off and back on or what.
Okay, I don't know, you can't hear me now? I'm so sorry, Your Honor.
I can hear you now, but there are times when you just go out.
Okay. We can try again. I can try on a different laptop, maybe. I'm not sure. I'm really, really sorry about this.
You're sounding fine right now.
Yeah.
Okay, breathe. Right.
Stay in the position that you're in now. Try not to move too much.
I'm so sorry. So Judge Stacker, I was explaining that the case that's really important here is United States versus Robinson, which compels the result that we're talking about the same claim. Because in that case,
right, I understand. What about our case? And we seem to have a couple cases on this. What about United States versus Zayed, where we said to preserve an argument on appeal, the defendant must object on the same basis below as he contends is error on appeal?
Right, and I think what they're talking about, the same basis below, means the same claim. Because in U.S. versus Robinson, the defendant below made an argument that the criminal history score was wrong because he only served a day of probation. But then on appeal, Your Honor, he made a very different argument that the prior conviction was just relevant conduct, which was a part of the instant offense. And the court still said, no, it is the same claim, the same broad claim that the criminal history score was wrong. So in that sense, Your Honor, here, the claim is that the South Carolina statute does not qualify as a serious drug offense. So it's just in E versus Escondido, which Robinson relied on, the Supreme Court said, look, any argument can be made in support of the same claim. But Your Honor, even if plain error applies here, the government hasn't met its burden because it's plainly not showed that with certainty that the statute is divisible by drug type. And Your Honor, the reason for that is that there's three reasons. There's three features of the proximity statute that make it clear that it's not divisible by drug type. And this is when we look at the statutory penalty, we look at the primary sentence, and we look at the structure of the statute. So first, Your Honor, the statute does have different penalties for different drug types. Before 2010, it did when the penalty was more severe than that for other drugs. But now, the statute just has a single penalty for all drug types. And Your Honor, this stands also in stark contrast to the other South Carolina distribution statutes, which are substance specific, those do vary based on drug types and drug quantities, creating distinct crimes in distinct subsections with distinct penalties based on drug type and drug quantity. So, Your Honor, the South Carolina legislature clearly knew how to make a statute which was divisible by drug type, as they did in the pre-2010 version of the proximity statute, and as they have done in the substance-specific statute. But they've made a conscious decision not to do so in this statute, in the current version of the proximity statute. Second, Your Honor, the primary purpose of the statute centers on location, not drug type. So it's about targeting drug activity in proximity to a school or park, regardless of the drug type. And this purpose, Your Honor, is further reinforced because the statute requires...
So I understand you're arguing about divisibility and whether that was plain at the time, but was it plain? Was there a definitive ruling about which version of the Federal Controlled Substances Schedule governs in determining whether a prior conviction constitutes an ACCA serious drug offense? Like what we look to, the state of the conviction at the time, the state conviction at the time, or the federal at the time of the federal sentencing? Well, how was that plain?
Your Honor, the timing doesn't matter for purposes of our first argument because there's no dispute here that the South Carolina statute has always criminalized some drugs which have never been criminalized under the federal statute. So, for example, Your Honor, the government here agreed that the South Carolina statute in 2013 criminalized isomers, non-optical isomers of depressants and stimulants. Well, they have always been excluded under the federal schedule. So it's fine that the statute is overbroad and indivisible by drug types, and there's not a timing problem with respect to this first argument. So again, if the court finds it's overbroad and indivisible, there's no dispute about timing because the ACCA didn't act at the time of the conviction, and it doesn't act at the time of the conviction. So, Your Honor, going back to the primary purpose point, it's also important to note here, Your Honor, that this purpose is reinforced because the statute in 2010 was amended to include a knowledge element, which went to location. And that means that the defendant has to know that he's within proximity to a school or park, but there is no knowledge element that was added with respect to drug type. That tells us that location is an element, but drug type is not. And Your Honor, this is not to say that the harm to society varies based on the type of drug or based on the quantity of the drug, but that's why we have the other South Carolina distribution statutes, which are substance specific, because they do vary penalties based on drug type and drug quantity. So they do address the harm created by drug type and drug quantity. And Your Honor, it bears noting here that if the state believed that the penalty wasn't severe enough, based on under the proximity statute, it can always prosecute under the substance specific statute, which does vary penalty based on the drug type and drug quantity. And vice versa, Your Honor, if the state believes that the substance specific offense doesn't carry a severe enough penalty, let's say there's a small amount of marijuana which only carries a maximum of 5 years, the state can then prosecute under the proximity statute, which carries a max of 10 years and doesn't distinguish between drug type. So all of this is to say that if this court finds that the statute is indivisible by drug type, it's not going to lead to any win for defendants. And third, Your Honor, the statute doesn't distinguish between different drug types. It just refers to controlled substance, which is defined elsewhere in a separate definitional provision that contains the alternative types of drugs. This tells us that the types of drugs in that separate definition are just alternative means of the single controlled substance. And here it's really important to look at the South Carolina Court of Appeals decision in State versus Adams, which had a similar structure. In that case also, at issue was a first-degree sexual misconduct.
Even considering Robinson for the standard of review, can you tell me again what the claim was below that is the same now?
Yes, so Your Honor, the claim is that the South Carolina proximity statute did not qualify as a serious drug offense. It did not qualify as a serious drug offense because there was a categorical mismatch between the elements of the South Carolina statute.
But was that argued below as the reason?
Your Honor, it was argued because if you look at 101, JA.
What about all of this duplicitous indictment?
So that was an alternative argument that was made. So when we look at page 101, what the defense counsel said is that he's opposing this court's decision in U.S. versus Marshall because it was unpersuasive, was unproven. Opposing that court's opinion about the modified categorical approach analysis. So in that case, Your Honor, the court held that the proximity statute was divisible by conduct. It was divisible by purchase versus distribution of goods. But counsel, in saying he was opposing that, was saying that the statute is an indivisible overbroad offense because it includes the purchase of drugs, which is excluded under the ACCA. And then additionally, he was saying alternatively, look, if the Marshall court is wrong and there are two distinct elements in the statute, then the indictment, because it charged both of those crimes in a single count, it's dismissed. That's effectively what the counsel is saying when you read these two paragraphs, Your Honor, in JA 101.
But page 101 is a follow-up to your duplicitous argument, isn't it? And the argument below, in light of furlough?
Well, Your Honor, if you look at the first paragraph, he does say, I believe the Marshall court, and I think there's a typo there. It says forecloses my analysis because the Fourth Circuit have really not published a persuasive opinion that 445 is divisible. Modified categorical approach applies to big garble there. And then the next line, he says, so Your Honor, so I think my positions for opposing that. But I made a duplicitous indictment argument. So Marshall had nothing to do with duplicity. So he had to be talking about the categorical mismatch claim because Marshall didn't address duplicity at all. So it looks like the duplicity argument here, Your Honor, was an alternative argument. And
he's not talking about the serious drug offense. He's okay. Go ahead. But that's your JA 101 is your site for why this same claim was raised below.
Yes, Your Honor, and also in JA 159.
What?
JA 159.
159.
Yes, Your Honor. There too, there's a statement made in the beginning which says, Hope contends that his South Carolina convictions to distribute, sell, manufacture, or possess with intent to distribute near the school should not qualify as predicate conviction for purposes of the ACCA. And then it cites the U.S. versus Marshall, which was all about divisibility and the categorical. But Your Honor, if I may, even if this court finds that plain error applies, the government still has not proven its burden because it hasn't pointed to anything at all to counter the three features that I talked about, which make clear that the statute is indivisible. Even under plain error, the government has not met its burden here because even on plain error, all we have to show is that the government fails to prove with certainty that the statute is It's important to look at U.S. versus Boykin here. In U.S. versus Boykin, also there, the defendant did not make a proper objection to the court's use of non-Shepherd documents. Yet the court found that there was plain error because honestly, the government did not meet its burden to produce Shepherd documents to prove with certainty that the statute, that the ACCA applied. So, Your Honor, in the same way here, the government has not proven its burden on appeal, even under plain error. Hasn't satisfied that burden. At U.S. versus Cantu and U.S. versus Tittle, where the 10th Circuit, consistent with this circuit's decision in Boykin, also found that there was plain error because the government did not prove with certainty that the statute was divisible by drug type. So, Your Honor, whether we apply the plain error standard here or whether we apply de novo review, the government hasn't given us anything. There's one case that the government cites to from South Carolina in support of its point, and that case actually does not help the government because it just reinforces, by contrast, that the statute is actually indivisible. The case they cite to is State versus Wilson. And in State versus Wilson, the court found that there was no double jeopardy when the defendant was prosecuted twice, once for conspiracy to traffic marijuana and once for conspiracy to traffic cocaine. But this was under the substance-specific statute in which the penalty varies based on drug type. So in that case, there were two distinct offenses with two distinct crimes in two distinct subsections with two distinct penalties. But that's not what we have here. In stark contrast, we have a single crime with a single name with a single penalty that does not vary based on drug type. So for all these reasons, Your Honor, the government has not met its burden to prove with certainty that the statute is divisible by drug type. Thank you.
May it please the court. The district court did not commit plain error in sentencing Hope under the ACCA based on his 3 marijuana trafficking convictions. First, Hope's claim is reviewed only for plain error because his claim on appeal that marijuana no longer is covered under the Controlled Substances Act is fundamentally distinct from his trial claim that he was subject to a duplicitous indictment under furlough. At trial, Hope never mentioned the 2018 elimination of hemp from the definition of marijuana.
Well, now opposing counsel cited me to JA 101 and more specifically JA 159, which was a written objection that he suggests preserves his claim. What is your response to that?
I disagree with that, Judge Thacker, because there's nothing. I'm looking at JA 159. There is no mention at all of the elimination of marijuana from the CSA in 2018. And as you correctly pointed out earlier, you mentioned the Zayed case, which says that the claim at the district court has got to be the same on appeal in order to preserve it. And not only did this court mention that in Zayed, but it actually mentioned it in furlough as well in evaluating a claim. Judge Gregory?
Your response goes to specificity as opposed to whether or not the area. The objection was that it does not qualify as an appropriate predicate offense in the ACCA. That's the objection. Now, you're right. It could have gone further and said, oh, it's the 2018 change. That's specificity. But the area, that's why he cites Marshall, dealing with that aspect. You're right. It does take a lot. As a matter of fact, what makes it interesting is that counsel raises it and then sort of said, well, I'm not sure it's going to be prevailing, but I want to preserve it for the Supreme Court or for an appellate court later. He talks about that. But he does say it does not qualify as a predicate. And that's what we're here today. Is it an appropriate predicate to enhance a sentence based on make someone an ACCA? That's the argument, but you're right. It could have been more specific as in the detail, but that is why we hit it, is it not?
Well, Judge Gregory, the idea that you can make an objection on the basis of overbroad statute at that level of generality and preserve an issue on appeal dealing with a specific claim that Congress in the 2018 definition of marijuana eliminated hemp as a definition is fundamentally different. And it's our position that that does not meet the same basis claim that this court referred to in
what about our opinion in Green, which cites to Robinson, that says once a defendant raises a claim before the district court, he may make a new argument for the claim on appeal without triggering plain error review?
I'm not sure that that particular statement can be considered to be correct in light of Zayed and again in light of Furlow, which also involved ACCA predicates. It is generally the rule that the reason you want to have objections made in the district court is to allow the district court to consider the objection and to make a ruling on it, and then to therefore allow this court to make an informed judgment. But in a case in which the defendant never even mentions the term marijuana, much less the fact that the statute has been changed in 2018, tells us that that claim down below was not preserved for appeal. What the defendant was talking about in Furlow and looking at the cert petition that was filed in that case was that if you looked at the consequence of the ruling in Marshall, which made 445 a divisible statute, that resulted in a duplicitous indictment because prosecutors would allege several offenses in a particular indictment. Marshall, again, had nothing to do with the 2018 elimination of marijuana from the statute. And so it's our position that unless you have the same basis at trial as you have on appeal, the issue is forfeited and you will review it for plain error only.
Let me ask you, at least in terms of plain error and where we're going, because it's always interested me when we deal with things from a procedural perspective, but I understand the limitations we have here. But I'm looking at it in terms of, okay, we go plain error, and then the question comes up, well, is this a plain error? And if it seems like to me the biggest determination here would be, well, what is the federal comparator? Is that going to be at the time of sentencing, or is it back at a different time? And if the court knows that it's at the time of the sentencing, then you've got two different schedules right in front of the court there. Why is that not plain?
It is our position that under the ACCA...
Now you understand where I'm going. I'm not getting to the question of whether we're going to make that determination right now as to should it be at time of sentence, but under that analysis, if that's true, in other words, that we use the sentencing and you do have the two different schedules, you would acknowledge, over breath, I think you pretty much acknowledge it would exist under that kind of circuit. But the question is it plain?
If the assumption is that you use a time of sentencing approach under the ACCA, then
yeah, we already started. I want to start with that now, but we'll come back and deal with it. But I want to make sure, because we're spending a lot of time on this plain error, but it seems to me the question is really that. Because if we come to something different, you know, the over breath argument may, even though I know there's a contrary argument that may have already been there, which is the bigger question, but that seems to make it plain. If we find that it is at the time of sentencing, there's a federal comparator, is that not plain?
If it would be under the assumption that time of sentencing is the appropriate gauge. We submit.
Wait, so you said, so just to make sure I understand what you just said, if we were to determine that the time of sentencing is the appropriate gauge, then the government would agree that it would be plain error.
Yes, but we do not admit under any circumstance.
I know you don't admit that, but you said yes?
Well, my answer is it wouldn't be plain because there is no case interpreting the ACCA that has held that in making a determination as to whether a prior state offense is valid or not is determined at the time of sentencing. No case whatsoever. McNeil, on the other hand, the Supreme Court case, that's the closest case.
But that's the question before.
That's where we're going to go. But the question that she's saying, if we held that, there may be no case, but what we're saying, if this becomes the case, then that does establish the plain error. So then now we can, as I understand now, but you want to argue the fundamental underlying premise that was used here, that it would be at the time of sentencing. So that's a different question. So, but I'm just saying, so that's why I say we can talk about plain error all day long, but it really is that determination that could control this case, and you wouldn't need to get into this plain error business, whether it's been preserved, or whether he talked about modified, divisible, in the oral argument, that sort of thing. I mean, that's, it seems to me. Now, am I wrong on that?
Well,
that's the decision for us to make.
That is correct, Judge Wynn. My answer is that to satisfy the plain error standard is whether or not you apply time of sentencing, time of conviction, or time of federal offense, the error would not only have to be, there would be an error, but it would have to be a clear or obvious error. And as this court also said in Furlow, to meet the plain or obvious point, the error has to sort of leap off the page. And you said that at page 324, 928. It's not clear or obvious that time of sentencing is the appropriate measure or gauge. And our position is that it's not. For purposes of this case, because the defendant committed his offense before Congress changed the definition of marijuana in December of 2018, the savings clause itself would be an independent barrier to relief because he committed the offense.
So let me understand that. You're saying it's not clear or obvious that, and I don't know how that relates to plain error. That seems to be a question of law as to when it would apply. Then once that question of law is determined, you then look at that specific determination to determine does plain error apply. I just want to be clear. I think that's where you're going with it, but you use that term in conjunction with plain error is obvious. It's not clear, obvious, but we're not reviewing whether the sentence is to be done at whether the sentencing time is the time for the federal comparator or some other time on a plain error. That's a question of law, seems to me. Am I wrong on that? That is a question of law, right?
Right. Judge Wynn, the plain error standard has 4 components to it. There has to be an error. It has to be plain. There has to be a violation of
and I'm with you on that. But I want to be clear in terms of analyzing it. And I'm not saying you still have the plain error. It's just, but there is a threshold question of law as to what is the federal comparator and when do you do it, and that's law. And then once you get the law, then the question is, does plain error does that yield plain error at whichever time period you pick?
That's correct, Judge Wynn. When I used plain or clear or obvious, that is the definition of under the second prong of the plain error standard. There is an error, it has to be plain, and the term plain means clear or obvious. Now, for example, this court said in Carthorne, which is a case also cited in Furlow, that if there is a conflict in the circuits or the law is unsettled in a particular area, it's not likely that an error there is going to be plain. And what my argument is that if we're looking under the ACCA, there's no court of appeals decision that has ever held that in determining the validity of a prior conviction under the CSA, that you look at the time of sentencing. McNeil said for purposes of determining the validity of the prior conviction, you look at the time of the conviction. And so if you look at the time of conviction in this case, which was in 2013, the state definition of marijuana matched the federal definition of marijuana. So there could not be any plain error in the district court's disregard of the December 2018 definition of marijuana in this case. And assuming you were to disagree with that, then we would then say that as an alternative basis for affirmance, and certainly no plain error, that under the savings clause, which because the defendant's federal firearm offense occurred before the December 2018 amendment to the CSA, that the savings clause preserves the harsher punishment in this case. So you have
maybe if the guidelines, if when guidelines can be imposed, which ones you look at, does that help us? In other words, at least I know at least one circuit has said that when you impose a sentence, the district court is to consider the sentencing guideline range that's in effect on the date that the defendant is sentenced. And so it seems, if you follow that, and I'm not being argumentative, just want you to respond to it, that it would seem inconsistent to apply guidelines in effect at the time, but then a different timing as to determine elements. Using an older drug schedule, for instance, because it does attach a certain, according to the Ninth Circuit, at least for sentencing purposes, a certain culpability and dangerousness by doing it at the time that he's actually sentenced. And I know that's a guidelines case, and that may be your one distinction that you want to hang that hat on. And if you want to, that it clearly is. But I'm thinking, at least in terms of the logic of why would you do it one and not the other, is something that we ought to think about.
That's correct, Judge Wynn. And the reason the guidelines have a different result is because Congress, in enacting 3553, I believe it's A4, specifically say that you use the date of the guidelines. And guidelines 1B1.1 says, the date of sentencing. And so because you have both a statutory and guideline provisions that say that you use the time of sentencing to determine the sentence, and part of that under the guidelines is the reason you have one guidelines manual is to avoid any ex post facto problems. That is why guidelines results are different. Under the ACCA, under McNeil, the test is the validity of the prior conviction depends on the time of conviction. But I will agree that under the guidelines, because of the 3553 statutory provision 1B1.1, the results are going to be different. And that is why we think we can distinguish the Bautista case and the Abdulaziz case from the First Circuit, because they both involved guidelines, and both of those decisions squarely referred to the differing provisions under both 3553 and 1B1.1. By contrast,
it would seem the opposite would happen. I mean, if you're going to sentence someone, except for the statute there, and consider culpability and dangerousness, it would be the person would be on notice at the time that is going on, not of the lesser offense that can occur down the road at the time of sentencing. So it seems to be there's a strong argument that from a sentencing, at least from a policy perspective, you'd use that early one because that was what the law was when you did it. Now you can't get the benefit of something new. Now we're talking about in terms of importing an offense in for the purpose of enhancing a sentence. And part of that purpose is because we want to deal with the culpability and the dangerousness of what those sentences represent. And yet, if it has now been a determination at the time of sentencing that there is something different here that relates to that, as to what that sentence is, it seems like that's the one you would use in determining the elements of it. How do you respond?
Well, my answer is, again, Congress takes into account different policy perspectives when they enact different statutes. They had one policy objective or several in mind when they decided that the time of sentencing was the appropriate gauge for determining culpability under the guideline. But on the other hand, when they were talking about the ACCA and the Supreme Court's decision in McNeil in particular, it decided that it wanted to refer to the date of the prior conviction. And as the Supreme Court said in McNeil, one of the benefits of having a prior conviction time is that it permits a defendant to know at the time of his federal offense or at the time of federal sentencing what he is going to be facing. And that'll allow him to make a decision to plead guilty or not. But again, Congress has different policy perspectives and objectives in mind when it does different statutes. The ACCA is one statute. The sentencing guidelines in 3553 are another statute. I only have 3 minutes left. I would like to respond.
Well, let me ask this because it's interesting. I think from the perspective of the defendant, there's other things. If let's say we did go with the idea that with the proposition that is at the time of sentencing, what happens if that actually sentences it actually, instead of being overbroad, now it becomes in line with the one. In other words, seems like to me it could work both ways. What is the prohibition from that?
Well, you're absolutely right, Judge Wynn, that sometimes it helps the defendant if Congress subsequently lessens the penalties, or in a case where, for example, as you point out, maybe 5 years down the road, Congress will add more drug types into.
Or to simply align it in line with this. The state law is now aligned with it. And the federal law now becomes aligned with what may have been overbroad with the previous law, but now it's the same thing. How does that work?
Well, it can work differently depending on certain circumstances. If they align it in the sense that they increase the drug types and then make the punishments potentially more severe, you could have some ex post facto problems with respect to defendants who commit their offenses before the effective date of the increased punishment. That is why, again, simply for purposes of this case and under plain error review, there was no plain error in not using the 2018 version of marijuana at the time of this offense or at the time of this particular sentencing. One quick question. I would like Judge Wynn to talk about the divisibility point. Since this is plain error review, the defendant has the burden to show that this statute is plainly indivisible. Now, our argument here is why this is not plainly indivisible is because in the Wilson case, the South Carolina Supreme Court viewed marijuana and cocaine as different elements under a block.
Is that the unpublished case? Is that our unpublished case on it? Is that not?
Oh, no, that's a published decision. That's a published decision.
I know we had it. Seems like we had an unpublished case that's pretty much on point. One of these cases, was that this one?
No, what happens, Wilson says that marijuana and cocaine are elements under a block burger test. That's under section 370. Then, yes, the Marshall case, which you're thinking of, is the case in which this court said that 370 and 445 are pretty much indistinguishable. So our point is that if that is the case, it wouldn't make sense for the South Carolina Supreme Court to make drug type an element for one statute in 370 or another one under for 445. But our point is all you have to rule here today is it's not plain error, reserving it for another case in which the issue is preserved to decide whether drug type is an element or a means under 445. Are there any further questions, Judge Gregory?
Yes. McNeil dealt with a change in state law, did it not? And the court said that you can't use a change in state law to impact the application of federal law. Here, this is a change in federal law involved. It does not,
Judge Gregory.
Doesn't foreclose us from reaching or deciding that it's at the time of sentencing. So that's not correct. A misreading of McNeil, isn't it?
Well, here's the reason. I know I'm over time, Judge Gregory, but you've raised an important question I'd like to answer. Here's why you should use the time of the definition at the time of the conviction. Because the serious drug offense not only punishes state offenses in subsection A2, but it also punishes federal drug offenses in subsection A1. Now, you would obviously, under McNeil, if it's a backward-looking statute, you would look at the definition of the federal drug statute at the time of the conviction. You wouldn't look at it then if the federal definition of marijuana changes down the line. In other words, to be consistent, the definition of the federal crime and the definition of the state crime, which is under A2, would be looked at the same time. And both of them are, in our point, is that you look at them at the time of conviction. Otherwise, if you look at the change in the federal law, then that would play havoc with the federal offenses under A1.
Well, that's your argument, but the point is that McNeil does not foreclose our decision if we said it was at the time of sentencing, as you seem to propose in your first argument. I appreciate that's your argument, that's your spin on it, but that's not what McNeil, in terms of forecloses their conclusion. But do you concede that this is a divisible statute?
No, I'm saying the defendant.
I'm asking you, do you concede that the South Carolina statute would be divisible in looking at this in terms of the categorical approach?
I think it is divisible in purposes of drug type for the reasons that I gave to Judge Wynn. But remember, it's the defendant.
Do you agree that it would, based on what the change has been, that it sweeps too broadly now when compared to the federal offense?
Judge Greger, are you talking generally about drug offenses under South Carolina?
No, I'm talking about the South Carolina at that time of his conviction is swept larger.
The general drug statutes in South Carolina were broader. And when you don't have a categorical match, then you can use the modified categorical approach to determine whether the offense at issue, in this case marijuana, is divisible by drug type or not. And our answer,
yeah, but here's a big mistake in a lot of analysis. Once you determine it's divisible and find out that part is a separate offense, then you still have to apply a categorical approach to that aspect of the divisible part. You don't just go, you still have to, and it still sweeps too broadly. And that's plainly by the reading of the statute, isn't it? Once
Judge Gregory, right.
Go ahead.
Judge Gregory, our point is that as we said in our brief, the general drug statutes in South Carolina were broader than the federal statute. They include a lot of methamphetamine offenses that are not currently included. When you have that situation under Mathis, then you look at the particular offense, state offense, in this case, marijuana, and decide whether on the modified categorical approach it states an offense or not. And our position is that it is divisible. The drug type is an element. It's not a means. We follow the logic of Wilson. I know I'm way over time. I'm happy to answer any questions you have, Judge Gregory.
Yeah, but that's the whole aspect of it. The question is, does the state law, that part that's divisible, sweep broader than the offense in terms defined by the federal court? And now you have a carve out of him. Then you did not, correct?
No, what I'm saying in terms of—
I know what you're saying. I want you to answer my question. You have a carve out for him now, right?
Yes, well, the reason is because at the time of his conviction or at the time of the federal offense, the state definition of marijuana was congruent. It wasn't overbroad. It was congruent with the definition of marijuana in the federal CSA.
I understand that, but you're still stuck on, and you're well reserved that you disagree that you should look at it at the time of sentencing. But if you look at it at the time of sentencing, it sweeps too broadly now, does it not?
Oh, at times of sentencing, right? But our argument is— yeah.
That's my whole point. I know you're reserved that. I'm saying, but if you get there, it sweeps too broadly in a categorical, in a modified structure. Yes, it does, doesn't it?
Yes, Judge Gregory, I agree with you. That is why our position has been that you do not, under any circumstances, look at time of sentencing in this case.
I understand. That's why you have to hold on to that. Right. Okay.
I'm sorry, Judge Gregory, any further questions? I know I'm way over time. I'm happy to answer anything.
Yeah, I'm about to ask my colleagues. Do you have any further questions?
I don't.
Thank you, Mr. Booth. Mr. Patel, you have some time reserved.
Yes, thank you, Your Honor. So, Gregory, I think you got it right on McNeil. McNeil was about what state law do we apply to the prior state offense? And of course, when we're looking at previous convictions, it only makes sense to look at what elements the defendant was convicted of at the time of the conviction. The elements of the offense that come after the time of the state conviction don't matter because that's not what you're convicted of. But that does not translate to, the logic that we apply an outdated version of the ACCA at federal sentencing. Let me give you an example that makes the government's position really absurd, Your Honor. Let's say there was a 1983 conviction and it was a first-degree premeditated murder conviction. Well, under the government's theory, that could never qualify because there was no ACCA in 1983. So their position is completely illogical, Your Honor. It only makes sense to apply the current version of the ACCA at the time of the federal sentencing. Because as Judge Wynn was saying too, when Congress said we're taking out a prior because it no longer warrants an ACCA sentence, somebody's no longer culpable based on that prior for an ACCA sentence, it's illogical then at the time of the ACCA sentence to apply a 15-year sentence for something Congress has said there shouldn't be a 15-year sentence. And that's
so in essence, my earlier question to your opposing counsel, this could cut against a defendant too, if you went strictly with the way in which you want us to go, and that is at the time of the sentencing, that if that offense, which at the time of conviction would not have been permitted, but at the time of sentencing it does, because now the federal law, That doesn't seem like it would be something you're going to agree to.
Well, Your Honor, that is the consequence sometimes where, the ACCA could get worse, right? If Congress makes it worse, the Congress could add an offense that makes you more culpable. So there would be an ex post facto argument, if the law changed after you committed the offense. But if it was changed before you committed the offense, then you're right. That's the way it would be. But Your Honor, it doesn't make any sense not to apply the current sentence. And there is no circuit split on that issue, Your Honor, because the two circuits that have decided the issue, although it was in the guidelines context, it's the same reason it applies in the ACCA. And so, it is plain that we apply the law of sentence. But there's one thing I wanted to clarify to you, Your Honor, is that if I could have a minute.
Yes, go ahead.
Gregory. So I wanted to clarify that, the timing doesn't really even matter for our first argument, because the government agrees that that the category that the statute is overbroad. So it's clear whether you look at the time of sentencing or whether you look at the time that of the prior conviction, that at that time there were offenses, more offensive in the South Carolina statute, more drugs were criminalized under the ACCA. The marijuana thing is our second alternative argument, but everyone agrees that at the time, in 2013, when these offenses, when the convictions occurred, at that time, there were some drugs that were excluded under the ACCA, even at that time. So whether you look at the time of the federal sentencing or whether we're looking at the ACCA law at the time of the state conviction, it's still fraud. It doesn't matter, Your Honor. So if you do find that the statute is indivisible by drug type and you look for all the reasons for it, that means that whether you look at the time at the federal conviction or at the time of the prior state convictions, you come to the same result, Your Honor, because the government agrees that historically there are some offenses that were always included under the South Carolina statute that have always been excluded under the ACCA. So, Your Honor, if the court doesn't have any further, there are two other points that I just wanted to address too. Again, State versus Wilson does not help the government at all, because that was in contrast to our statute. That was a statute that was clearly divisible because it had different penalties based on the drug type, which is in stark contrast to our statute that doesn't have different penalties, that has a single purpose. Primary purpose is about location, not drug type. And one other question I wanted to answer, Judge Witt, you said there's some unpublished decision. The unpublished decision of U.S. versus Marshall, which is completely inapposite here. That was saying that the proximity statute is divisible by conduct, purchase versus distribution of drugs, but that's obvious because there's different statutory penalties for purchase versus distribution. So it's divisible by conduct, but that did not whether honor. And so for all the reasons I've given you, and the government given you a single substantive reason for why the statute is divisible by drug type, that tells you there is error and there is plain error here, Your Honor. It is an overbroad, indivisible statute that never should qualify as an ACCA serious drug offense. And we're talking about somebody who was sentenced on one day for 3 priors that involved a very small amount of marijuana, and he got a 15-year sentence, Your Honor. That cannot be justified either under the categorical approach or under the modified categorical approach. Thank you, Your Honor.
Thank you, Ms. Patel, and thank you, Mr. Booth, for your fine arguments. And we can't come down and shake your hand, but know that we appreciate you very much helping us on these cases, and we wish you well and that you will be safe. We'll ask the Deputy Clerk to adjourn the court until this afternoon.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.